submits that the petitioner is not named in the FIR, although he is alleged to be the driver of the vehicle which ultimately killed the driver of the tractor. It has been alleged. Yes. It has been alleged that that's it. It has been alleged that the petitioner was the driver of the tractor which moved back to kill the child. The learned counsel for the opposite party has opposed the prayer and has submitted that the entire narrative in the FIR reveals that on 27/12/25, the wife of the informant was branded as witchcraft practitioner, and her child was snatched away and assaulted, and she had put the child in front of, behind the tractor and asked the driver to move backward, pursuant to which the driver moved backward. She submits that the entire incident was witnessed by the eyewitness, including the informant of the case, and therefore the petitioner may not be enlarged on bail. After hearing the learned counsel for the parties and upon going through the case diary, which reveals that there are eyewitnesses to the occurrence, making direct allegation against the petitioner, who was the driver of the alleged vehicle. This court is not inclined to enlarge the petitioner on bail.
Only my submission will be recorded.
Yes.
Although not named in the FIR, but he has to put on here. That is my submission.
He has not been named in the FIR and has not
been put. And the charge sheet is submitted only under section 281 and 106 of the BNS. No witchcraft, nothing.
That charge sheet is not mentioned. It's not there.
It's not there, but it
so
is
how
come
do
in
I
the
record
order.
it?
It is come in the order.
Cognizance order has been.
Yes, but cognizance they can't give it. That will be written.
It has not come under the section that charge sheet has been submitted.
Serial number 2, BA3305
He has not been put under PI.
BA3305 of 2026.
By order of 13th of March, 13th of April 2026, I directed the ACB to file a response, and particularly pointing out the materials.
You were also supposed to file a supplement here.
I have filed.
What is the period during which you were the director of the company?
I was director earlier 2009 and 10, but primarily 20th of November 2024 to 5th of March 2025. That has been noted in paragraph 8 of the order, 13th April. And the alleged crime period is of 2022. Much prior to when I was there.
So you will respond to the materials which have been placed on record by the ASP.
Yes.
You just place the materials on record which has been collected against him, because he has placed on record the period during which he was the director, and now you tell us that how is he linked with the offense.
But there are, in fact, my specific statement is in para 8 and 9 of my affidavit.
Let's see. Eight and 9. Yes, please.
May I please? that at the outset it is further stated that the petitioner was issued notices under section 35(3) of the NSS on several occasions, including first notice dated so and so, so and so, so and so, so and so, but the petitioner had not cooperated with the investigation and was unwilling to identify himself. That, however, after the arrest of the surrender of the petitioner pursuant to the order passed by the Honorable Supreme Court, petitioner has cooperated with the investigation and has even got his statement recorded under 183 BNSS before the Judicial Magistrate First Class Magistrate.
Has he admitted his guilt?
Pardon?
Has he admitted his guilt?
But he has stated the facts which corroborates with the facts with respect to the other cases.
No, you just place his 183
Yes.
statement. Read it out, please. You read out this 183 statement.
Yes.
You have got a copy? Do you have a copy for yourself?
I have a copy of it.
You read it.
It's at page 1 of the case diary.
Yes.
आपको अपने बयान में क्या कहना है? वर्ष 1998 से मेरा परमिट छत्तीसगढ़ डिस्टिलरी में दूध में संचालन कर रहा था। इस फैक्ट्री में हम लोग करीब 31 साल से कंट्री लिकर एवं फॉरेन लिकर बना रहे थे। वर्ष 2018 में मेरा जान पहचान श्री अरुण त्रिपाठी जो कि छत्तीसगढ़ स्टेट बेवरेजेस कॉर्पोरेशन के एमडी थे और अरुण अनवर तिवारी जो एक रायपुर के व्यापारी थे, इनसे हुई। दोनों व्यक्ति बहुत प्रभावशाली थे और छत्तीसगढ़ सरकार की अल्कोहल पॉलिसी में इन दोनों की बहुत चलती थी। इस तरह से सरकार का अल्कोहल व्यापार यही दोनों चलाते थे। वर्ष 2002 मार्च से अरुण त्रिपाठी जी ने मुझे मिलने के लिए अपने ऑफिस बुलाया। जब मैं पहुंचा तो देखा कि अनवर भी वहां मौजूद थे। वहां उन्होंने मुझे बताया कि श्री विनय कुमार चौबे झारखंड के उत्पाद विभाग के सेक्रेटरी हैं, तो बहुत पावरफुल हैं। झारखंड में शराब का कारोबार की व्यवस्था वही चलाते हैं। उन्होंने ये भी बताया कि अरुण त्रिपाठी को झारखंड सरकार का सलाहकार बनाने के लिए श्री विनय कुमार चौबे को उनके रांची स्थित आवास पर 5 करोड़ रुपए की राशि श्री विनय कुमार सिंह जो कि महिंद्रा रांची स्थित डीलर थे के द्वारा पहुंचाई गई है। ये भी बताया गया कि आगे का सारा लेन देन उन्हीं के माध्यम से होगा। उन्होंने ये भी बताया कि इसके बाद अब अरुण त्रिपाठी झारखंड के शराब कारोबार में बहुत प्रभावशाली बन जाएंगे। ये भी बताया कि अब छत्तीसगढ़ के तर्ज पर ही झारखंड एक्साइज पॉलिसी होगी। अनवर ने मुझे बोला कि अब आने वाले समय में आप लोगों को भी झारखंड में कंट्री लेकर सप्लाई करना होगा। इस बात को मैंने विरोध किया कि मैं झारखंड में सप्लाई नहीं करना चाहता, तो दोनों ने मेरे ऊपर बहुत दबाव डाला, धमकी तक दी कि नहीं करोगे तो लाइसेंस कैंसिल कर दिया जाएगा और बिजनेस पूरा खत्म कर दिया जाएगा। इस दबाव के चलते मैंने बेमन से उनकी बात मान ली। उसके उपरांत मुझे उन्होंने बताया कि 2 कंपनी दिशिता वेंचर एंड होम साइड बेवरेजेस ही झारखंड में पूरा शराब का होलसेल का काम करेंगे। मुझे डायरेक्शन दिया गया कि 2 दिन में सहमति पत्र मुझे होम साइड बेवरेजेस को देना है कि मैं उन्हें सप्लाई करने के लिए तैयार हूँ, जो मेरे द्वारा होम साइड बेवरेजेस को दे दिया गया। उसके बाद मुझे पता चला कि दिशिता एवं होम साइड
मेरे द्वारा होम साइड बिजनेस को दे दिया।
हाँ, ये होम साइड को दिए थे।
कौन ये दिए थे?
आपका
कौन सा डॉक्यूमेंट?
पर ये नहीं, मतलब उनके कंपनी दिए थे।
He is not the director of that company. He is nobody in the company.
That's correct, my lord. I
Then,
said,
how do you link an individual person? You see, he is nobody. It must have come from the company.
that letter has come from the company.
Then how is he linked? How is he linked?
But
Had he disclosed that he was not the director of that company during the relevant point of time, your entire investigation would have been different. Maybe that he would not have been made an accused in this case.
correct, my lord. In fact, my lord, initially when we have not arrested people who have cooperated with the investigation.
That's right.
Here is the
No,
case.
it's okay. You see, now it's a case of regular.
I know.
So you cannot, it is not an anticipatory way, where we have to see whether he has cooperated, not cooperated. We will only see that what is there to link the petitioner with the alleged offence.
Correct.
And you see, this then he gave it. This is not supported by any material. हमको तो कुछ नहीं मिला.
नहीं, but
आप इतना बड़ा केस डायरी हमको दिया, लेकिन हमको कुछ मिला नहीं, इसलिए हम आपसे पूछ रहे हैं.
हम तो कह ही रहे हैं कि जो मतलब when we are making an investigation, like a statement of one Siddharth Singhania case.
नहीं, देखिए, whenever we are talking about an individual, आपसे ज़्यादा company और individual का differences.
Correct.
It has not even come that he was somebody in the company, he was the manager, nothing. That is not there.
That has been revealed, but I have admitted that also in my
Yes.
reply to the supplementary affidavit.
Yes.
That has come that he is not, for that period, he was not the director or anybody in the company.
Maybe that
He was there
it
for the-
never came to light prior to this. Except the statement made earlier, अभी तक तो आपने इनका status of director भी कभी verify भी नहीं किया. और इनके पिटीशन में भी कहीं नहीं था. It was only on that day he made a submission that he was not the director. He
पहले
was
के जो
asked.
petition फाइल हुए थे उसमें ये डायरेक्टर लिखे थे अपने आप।
लिखे होंगे,
हाँ,
लेकिन
अपने
now
आप
he has
को-
produced the relevant
हाँ,
document.
तो better legal advice, better counsels and
अरे भाई एक आदमी को क्या ही पता है क्या बोलना है क्या नहीं बोलना है.
करेक्ट, हम उसको नहीं कह रहे, पहले जितने पिटीशन में सब में डायरेक्टर लिखे थे, हम लोग भी डायरेक्टर एज्यूम करके चले।
I
और
understand.
आज इस कंपनी के बारे में जो भी जितने भी विटनेस बोले, तो इन्हीं को एक ऑल्टर ईगो बना के रखा गया था कि कंपनी की यही ऑल्टर ईगो है जो डील करते हैं।
जबकि ऐसा कोई मटेरियल आपके पास नहीं आया, कोई इनके साथ कोई मनी ट्रेल नहीं है, इंडिविजुअल कैपेसिटी, इसीलिए आपसे पूछ रहे हैं, बिकॉज ही हैज टू रिस्पॉन्ड टू व्हाटएवर मटेरियल्स यू हैव कलेक्टेड ड्यूरिंग इन्वेस्टिगेशन.
So I have stated very fairly in para 7 and 8 of my counter, and his medical condition also we have responded. It's an admitted fact. He is under treatment in this, and whatever is there, my lord, we have just stated. The statement of Siddharth Singhania is there.
Let me see that also.
Yes.
Who is Siddharth Singhania?
Well, he was one of the persons who was also dealing with the liquor trade business. We had arrested him, and then he had given the statement.
Is he related to this company?
No, he is not.
क्या बात है? अब आप ये बताइए कि because he was arrested from Goa, it seems.
Yes.
तो आपको क्या कंडीशन इम्पोज करना था? नहीं
हाँ, मतलब conditions में मतलब I would request मतलब that some conditions may be there. Passport वाला एक condition कर दिया जाए.
ओके.
And मतलब of course close relative may be the bailer. And
बेल बॉन्ड कितने का होना चाहिए?
minimum 5 lakhs कर दिया जाए. And he should cooperate. मतलब he has cooperated now, and he should cooperate. That's all.
Whenever he is asked for
Yes.
to come, he will
Because
come.
now we will have.
बस 3 दिन का उनको टाइम दे दीजिएगा.
हाँ,
He is
दे देंगे।
you are a resident of छत्तीसगढ़. 3 दिन का टाइम दे दीजिएगा.
3 दिन 7 दिन 5 दिन जो भी है.
और मेल आईडी आपको दे देंगे.
हाँ,
फोन नंबर आपको दे
हाँ,
देंगे.
ठीक है.
और कुछ चाहिए?
नहीं.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. And the allegations reveal that in the liquor scam in the state of Jharkhand, the आपकी कंपनी का क्या नाम है? कंपनी
Chhattisgarh Distilleries Limited.
Chhattisgarh Distilleries Limited was one of the suppliers of liquor through
Homeside. Mrs. Homeside Beverages.
through Messrs. Homeside Beverages. And it was Messrs. Homeside Beverages which entered into agreement for supply
That's a wholesale license.
as a wholesale licensee. The learned counsel has submitted that pursuant to the last order, a supplementary affidavit has been placed on record indicating that the petitioner was the director of the company of Chhattisgarh Distilleries only during the period 2/10/2009 to 10/5/2010, and then from 2011-2024 onwards.
253/2025.
To 5/3/2025, and the entire alleged offence in the present case in connection with Chhattisgarh Beverages Private Limited is of the year 2022.
Chhattisgarh Distilleries or maybe Homeside actually.
Chhattisgarh Distilleries / Homeside Industries. He has also submitted that at the time of the alleged offence, the petitioner was not connected with the company, and the documents annexed with the supplementary affidavit are the statutory documents which shows the period of directorship of the petitioner. The learned counsel has also submitted that no link in connection with any money or otherwise has been found against the petitioner. His statement was recorded under section 183 BNSS, and in the statement, the fact that the petitioner was not the director of the company during the relevant point of time was not disclosed, and it appears that under such circumstances, the petitioner has been made accused in this case. The learned counsel submits that there is nothing on record to link the petitioner with the alleged case. The learned counsel for the opposite party has opposed the prayer and has referred to the counter affidavit of the victim. Has referred to the counter affidavit, referred to the counter affidavit and the statement made by the petitioner under section 183 BNSS, and has submitted that and has placed the entire statement he has submitted that as per his statement, the petitioner met the co-accused Arun Pati Tripathi and Shri Anwar Devor in their office at Raipur, and he was asked to make supplies for the sale of liquor, supplies to Homeside beverages who were to supply liquor in Jharkhand. He has further submitted that the necessary document for the supply was issued to Homeside beverages as stated by the petitioner in his statement under section 183 BNSS. He has further submitted that the co-accused, namely, क्या नाम बताया उन्होंने? Siddharth Singhania, has also supported, whose statement has been recorded under section 180 BNSS, has also supported the presence of the petitioner in the entire transaction. यही है ना? However, during the course of hearing and upon a query of this court, the learned counsel for the opposite party has fairly submitted that so far as the document issued to Homeside beverages is concerned, the same does not contain the signature of the petitioner, and it is not in dispute in the counter affidavit that during the relevant point of time in the year 2022, the petitioner was not connected with the company, namely Chhattisgarh Distilleries Private Limited, who was the supplier to Homeside beverages. it further appears that the petitioner is under treatment in RIMS branch and he is in custody since
10th of March 2026.
10/3/2026. The Learned Counsel has also submitted that in the previous petitions filed by the petitioner, he had disclosed himself to be the padvicar of the petitioner had disclosed the petitioner to be the director of the company. And therefore, there was no doubt in the mind of the prosecution that the petitioner was the director of the company. The fact that he was not the director of the company in the year 2022 has been brought on record for the first time in the supplementary affidavit placed before this court. After hearing the Learned Counsel for the parties and considering the materials placed on record, it is not in dispute so far that the petitioner was not the director of the company on the date and the period of the alleged offence. Company namely Chhattisgarh Distilleries Private Limited, and as per the allegation, it was Chhattisgarh Distillery Private Limited who was the supplier to Om Sai
This is not
Industries
private, it is only limited.
Limited, who was the supplier to Om Sai Industries, and who in turn was to supply liquor in the state. No document or other material has been placed on record or indicated by the Learned Counsel for the opposite party to otherwise link the petitioner with the alleged offence, apart from his statement recorded under section 183 BNSS that he met the co-accused when the co-accused had asked the petitioner to make supply. Admittedly, there is no supply by the petitioner in his individual capacity. It is not even the case of the prosecution that the petitioner was holding any position in that company. In view of, charge sheet has been submitted. In view of the aforesaid facts and circumstances, the petitioner is directed to be enlarged on bail, subject to the following conditions as indicated by the Learned Counsel for the prosecution. He will deposit the passport. The padvicar in this case will be the bailer, one padvicar. Other will be the close relative, 5 lakhs surety. There are other conditions we normally give, that he will give the Aadhaar, then the mobile number, and he will retain the mobile number throughout. The petitioner would cooperate with the investigation of the case. He will also furnish his email ID. The prosecution, as and when required, will intimate the petitioner for his appearance at least 3 days in advance. In case of default of even 1 day, it will be open to the prosecution to take all course of steps against the petitioner. That's all.
Okay. We are saying that they don't come. Those who are coming, we are not arresting. We are just following the pattern of CBI so that we get evidence.
That is the whole concern.
हाँ.
That is the whole concern. मुझे तो इसमें ऐसा लगता है कि अगर इन्होंने बताया होगा ना अपने
पहले
183 में,
हाँ.
तो हो सकता है आपका इन्वेस्टिगेशन ही दूसरे डायरेक्शन में
हाँ.
था. You would have फाउंड आउट कि इनका क्या रोल था, इनका इंडिविजुअल कैपेसिटी में क्या रोल. How do you know that they are not the present में तो डायरेक्टर थे at that point of time?
Cooperation is minimum. At the initial stage, there was some cooperation with 7-10%.
And he is not a co-accused in Chhattisgarh case. Are you a
वो है।
co-accused in?
वो
नहीं.
उसमें हम लोग के ICGS में नहीं आया है ACB, but he
Are
is
you a
the-
co-accused in Chhattisgarh case also?
Not in the ACB matter.
Not in the ACB.
We have said so.
Yeah, I don't know. But from this लगता है कि इस तरह से तो थोड़ा मुश्किल है किसी को इस तरह से कोई इनका कनेक्ट नहीं है, कुछ लिंक नहीं है।
यही चीज आके बोले तो एक बार भी
183 में कोई बोला इनको होता तो हो सकता है आप इनको एक्यूज ही नहीं बना, या फिर दूसरा डायरेक्शन में इनका
हम तो
इन्वेस्टिगेशन।
35(3) का नोटिस ही दिए थे, 4 बार नोटिस दिए थे, एक बार भी रिप्लाई भी नहीं, कोई अपीयरेंस नहीं, कुछ नहीं। Everybody is presuming that we will arrest. Though our history is we have been only arresting those who have not been cooperating.
General apprehension of.
General apprehension because it is more than 7 years.
कभी कभी लगता है कि स्टेटमेंट देने के पहले थोड़ा सा वकील साहब से बात कर लेना चाहिए, थोड़ा सा डिस्कशन किसी का भी 183 का स्टेटमेंट
More than 7 years है तो 35(3) के बाद भी हम अरेस्ट कर सकते हैं, वो apprehension में कोई आ नहीं। That is the whole problem.
For admission, serial number 3, ABS 7264 of 2025.
possible.
Serial number 4, BA 11683 of 2025.
From the first information report, it appears that the informant is a greedy person, and he himself invested amount in the metal business of world market banks. Initially, he gained some profit, and subsequently, when he invested the money balance, lost. Can you see the first information report at page 11?
You have received the money in your
Not
account.
actually, I have also been made victim at the hands of the cyber
आपके नाम
offenders.
से इसी आपके नाम से अकाउंट है,
हमारे
and
पास
your statement is what your statement is recorded that this person came and then you agreed, you were in the
Yes,
crisis,
I am working
you
in-
agreed कि भाई मेरे नाम से अकाउंट खोल लीजिए, then you
Who
went
said
there.
Well, that he had no account balance. He was working as in a garment shop balance, as salesman balance, and thereafter he was allured by some persons to open an account, and that has been misused.
Allude. You see, somebody is opening the account in your name and you are alluded, and then he is using your ATM, he is using your bank account.
That was for except taking signature ballot, he has done nothing ballots.
काफी है सर, signature बहुत होगा.
And one of the co-accused having similar allegation ballot has been granted bail by this honorable court balance. By this honorable court.
No.
ये हमारे account में पैसा, he has not withdrawn any amount balance.
No.
That the amount was transferred, they are transferred to a different account balance. This is the case, man. This
वही
is
ना,
the
यही
case.
तो fraud है.
Kindly see, man.
नहीं ऐसे भी नहीं दे सकते.
इसको ये मांगा गया था डायरी और
हम देख लिए सर, डायरी देख के बता, इतना जो बात आपको बता रहे हैं ना, वो डायरी देख
I
के
am
बता.
not submitting anything beyond the record matter, which is in
I
the
know,
record that I have
I know,
submitted
sir.
matter. Page 14 matters, everything will be clear. Who is the person who has cheated him matters. Can you see? At page 14. It's not a case of such nature. Page 14. Complaint regarding online fraud involving transaction more than 3 crores. On 2 June 2025 to online advertisement, I opened online account at Chicago Board of Option Exchange to Global India site. Screenshot is there. Thereafter trading commenced on metals across world market. It commenced with a smaller amount of rupees 2,000, 7,000, 32,000, and at the end of each trade, I could withdraw money with profit that prompted me to get further involvement. Trading and all transactions were done on instruction by Niharika Mehta, connected through Telegram app numbers. Screenshots are given. At a later stage, I did one wrong trade, and my balance got frozen, and thus had to do large amount trade of at least my balance. I did trade, and my balance got unfrozen, but other types of problems offered, like credit score below 100 or VIP level reduced below 5. A sample of such status is given as a step 3. When all states became withdrawal, when all states became work withdrawal, I was asked to pay a fee of F8BF certificate and insurance, and subsequently withdrawal was through wise, but it was stuck. I was asked
ये आप कहाँ से पढ़ रहे हैं सर? From where are you?
Page 11, that is the FIR. That is the FIR, that is the main allegation.
That's it. That is.
That is the main allegation. Several account numbers have been mentioned. And those accounts numbers have been
Avoid the
misused
learned
by those
counsel for the
persons.
petitioner.
And the co-accused has been allowed by the city order granting regular bail to the co-accused. The case is a single case. And my confessional statement has also been recorded in this case, where from it that I am working in a shop. Garments. Custody is also about 9 months.
Heard the learned counsel appearing on behalf of the petitioner. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. Rather, the petitioner is a victim. He submits that though the cheated amount to the extent of rupees 26,68,050 has been found in the Indus-Ind bank account of the petitioner, but the same was opened by misleading the petitioner and by taking his signature. The bank account was never being operated by the petitioner. The learned counsel has submitted that the petitioner is in custody since
He is in custody since 3rd August 2025.
since 3/8/2025 and co-accused Goyani, Hardik Bhai, Kasri Bhai, क्या नाम है? आज नाम लिखेंगे इसका.
Now,
Has been granted bail by a coordinate bench of this court in DA number 11401 of 2025. Nobody appears on behalf of the opposite party.
he has also same allegation, same. His account number has also was misused.
उसमें order में नहीं.
The order that is in the FIR.
Order में नहीं.
The FIR. Can you see the order numbers? What was the reason? It has been alleged that their present case pursuant to the cyber crime network and the present petitioner along with others has
Sir,
taken
आप सुनिए सर आप. After hearing the learned counsel for the petitioner, this court finds that at this stage, this court finds that it is not in dispute that the bank account was opened in Indus-Ind Bank in the name of Jaspal Enterprises, in which the petitioner is the proprietor. And the defrauded amount was transferred in his account, amounting to rupees 26,6068,050. And then it was further transferred to other account.
Yes, that was transferred. That was not been done.
so far as the bail order granted to the co-accused is concerned, it was granted primarily on the ground that the petitioner of the state case had no concern with the illicit transmission. And accordingly, this court is of the view that the petitioner, the transaction is directly linked with the bank account standing in the name of the petitioner. The case of the petitioner does not stand on identical footing. Accordingly, the bail of the petitioner is hereby rejected. State that appearance कर दीजिए ऑफिस.
Period of custody 9 months.
कोई बात नहीं.
Serial number 5 BA11812 of 2025.
Counsel for the petitioner seeks permission to withdraw this application. Accordingly, this application is dismissed as withdrawn.
Serial number 6 BA11940 of 2025.
The possession of the petitioner, one mobile phone and one SIM card has been recovered.
One mobile, one SIM.
One SIM. And also petitioner is no criminal antecedent also. Is in custody lordship 28/9/2025. The material which has come in the diary lordship, that there is 2 victim lords in this case. This is
Amount
not organized
kitna
crime lordship.
Amount
because-
कितना है?
Yes, lordship. 111 also will not register. That is para 38 and 38A lordship. That is 30.
बताइए ना अमाउंट कितना
वही बता रहे हैं 33,888 रुपया और एक का है 3403 रुपया।
मोबाइल आपके नाम से है?
मोबाइल ये तो नहीं आया, लेकिन मेरे पास जो मोबाइल है उसी से कॉल गया था और उसी पैसा उसी से कटा था। और मुझे
Use for the state.
111 और नाइट क्राइम नहीं लगा है, नॉट राइदर
इतना
चार्ज।
एंशियस मत होइए, हम बेल दे देते हैं। प्रॉक्सी है आपका?
एक केस के लिए पास होना चाहिए। एक केस
आप रुक जाइए।
Serial number 7 BA11961 of 2025.
इसमें वन डेट काउंटर बन गया, फाइल
बन गया है? आपके पास है काउंटर?
काउंटर है कि सभी
फिर क्या बोलना है?
इसमें एक्चुअली वो कमिश्नर का सिग्नेचर नहीं हो पाया था, उनके लड़के का एक्सीडेंट हो गया था, उसी के चलते रुका हुआ था। लेकिन मेरिट तो हम पास कर रहे
मेरिट पे आपको तो पता ही है, काउंटर नहीं भी फाइल होगा तो कोई बात नहीं, उसकी जरूरत नहीं है। काउंटर इसलिए हम लोग मानते हैं कि आपको सारा मटीरियल एक जगह।
एक्चुअली हुआ था कि हम लोग बहुत सारा काउंटर बनाए, तो हम लोग वाइस कमिश्नर थे उसको वेरीफाई करते हैं, उनके लड़के का एक्सीडेंट 2 दिन से आ नहीं रहे।
इसी का काउंटर बनाने का पर्पस ये है, द स्टेट शुड नो कि क्या मटेरियल है, नहीं तो अचानक उसको असिस्टेंस में दिक्कत होती है। हाँ बोलिए।
एक मोबाइल फोन और सिम कार्ड मेरे पोजीशन से मिला है।
वन मोबाइल, वन सिम।
And in custody since 14/9/25. I got no criminal history stated at Parasite as well as in the counter.
बताइए क्या है इनके अगेंस्ट में?
और
विक्टिम
एक है 78 में आया हुआ पैरा में कि कुल 31,552 रुपया जो मोबाइल नंबर जो सिम कार्ड जो है 1049 उसी से ट्रांजैक्शन हुआ था पहले।
ये सही स्टेट हमारे पैरामीटर्स के अनुसार है।
मोबाइल सिम पाया गया था, उसी मोबाइल सिम से एक आदमी एक विक्टिम है डिस्ट्रिक्ट।
Or the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that, as per the allegation, one mobile and one SIM has been recovered from the petitioner, and there is one victim. He submits that the petitioner has no criminal antecedent.
No criminal.
He is in custody since 14/9/2025. The learned counsel for the state has opposed the pair. However, the aforesaid submissions made by the counsel for the petitioner is not in dispute. Considering the custody of the petitioner, co-accused किसका बेल हुआ?
संजय कुमार।
उसमें ऊपर ही लिखेंगे one co-accused has been granted bail. considering the custody of the petitioner and the fact that co-accused has been granted bail in BA number 12015 or 25, the petitioner is directed to be released on bail.
Serial number
ये
8.
डाल दीजिए इसके अंदर.
Serial number 8. ABA 270 of 2026.
Yes, sir.
Madam, this petition for non-compensatory to the petitioner who was not posted as Panchayat. Now this relates to not the case land scam, not this is not in the that happened. Not the Madam, can receive not the FI. Page 25. Mainly, Madam, this case has been lost. Because the reason not that is that so far plot number khata number 95, plot number 848, which was not the in the reports of right, it was mentioned that this is not the jungle. Page 25 not this is not.
Yes.
There were two khata number 73, plot number 812 and khata number 95, plot number 848. The last page of the last line of
You
the
can, we are seeing this FIR time and again. We have
Oh,
seen
yeah.
this
Yes.
FIR very closely.
Yes.
Now you tell us what is your case. Under your recommendation, everything has been done. How can you get rid of it?
Melody, this so far not the khata number 95.
And this is ABN, not
Yes.
in a regular
So far
way.
not the khata number 95 and plot number 848. Lord, that appears from Lord the page 26. Lord, I have been these are the 4 lines Lord the release.
Page number
Page 26.
26. Yes.
इसी खाता 95 में प्लॉट 848 से 28 डिसमिल जमीन विनय कुमार सिंह पिता सोलसो एवं श्रीमती सीता सिंह पति सोलसो द्वारा क्रय किया गया तथा दाखिल खारिज भी किया गया है, जबकि इसी तरह की जमाबंदी को गलत माना गया है एवं जमाबंदी तक रद्द की गई है तथा स्पष्ट है कि क्रेता विनय कुमार सिंह पिता साधु शरण सिंह एवं श्रीमती जीता सिंह पति विनय कुमार सिंह का खाता संख्या 95 प्लॉट संख्या 48 रकबा 28 भूमि का गलत तरीके से जमाबंदी किया गया है। इस अवैध जमाबंदी को तत्कालीन राजस्व कर्मचारी संतोष कुमार वर्मा, तत्कालीन अंचल निरीक्षक राजेंद्र प्रसाद सिंह एवं तत्कालीन अंचल अधिकारी श्रीमती अलका कुमारी द्वारा 18/8/2010 को क्रय किया गया है। प्रारंभिक जांच के क्रम में स्थापित हुआ कि उक्त पदाधिकारी कर्मी द्वारा पद का दुरुपयोग करते हुए क्रेता एवं विक्रेता के से आपस में षड्यंत्र कर सदोष लाभ प्राप्त करने के उद्देश्य तथा सरकार को हानि पहुंचाने के लिए से उक्त अपराध करें। So not the involvement of not the कर्मचारी that is
किसी को भी बिल नहीं देंगे, आपको क्या लगता है?
जी
किसी को भी नहीं देंगे। विनय कुमार चौबे का ऑलरेडी रिजेक्टेड है।
रिजेक्ट हुआ है but not the so far petition is concerned about
सर देखिए बेचने सेलर का आपको बेल दिए थे ना?
हाँ वो पावर अटर्नी होल्डर
पावर ऑफ तो हमें एक क्राइटेरिया तो अपनाना पड़ता है ना। These are the government officials, they are absolutely involved in the case.
not the but not the so far
यार
petition
120B लगा हुआ है ना साहब?
120 में तो लगी
काफी है।
ये
Not a case for anticipatory bail.
not the 120
उनको तो हम रेगुलर भी नहीं दिए।
मुझे यहाँ 120 के बाद 120B का मुझे 2 जगह तो 120B जरूर लगा दिया जाता है।
सर मैकेनिकल नहीं है।
नहीं इसलिए कि जो इस खाता नंबर जो
आपका तो स्टेटमेंट भी रिकॉर्डेड है कि आप गए थे, आपको फोर्स किया गया, शायद आप ही का है स्टेटमेंट।
नहीं मेरा नहीं
वो दूसरे का
दूसरे का
हाँ जिसका
जिनका ये
ठीक। सर एंटिसिपेटरी बेल का केस है ABA नंबर 270
एक चीज अब इनका है कि कर्मचारी इनको स्पॉट वेरिफिकेशन करना है। जब ये गए स्पॉट पर तो हुजूर था क्या कि जो लैंड था ऑलरेडी जो अमीन थे फॉरेस्ट डिपार्टमेंट वो जो है पूरा ट्रेस काटे हुए थे कि इतना जमीन जो है सो फॉरेस्ट है। ट्रेस के बाहर वाला जमीन मतलब ये माना जाता है कि जहाँ देख रहा फॉरेस्ट लैंड जो था वहाँ तक ट्रेन से कर दिए, ट्रेन के बाहर वाला जमीन फॉरेस्ट लैंड में नहीं था। अब ये स्पॉट वेरिफिकेशन करके वही रिपोर्ट दी कि ट्रेन का बाहर है, जो कि हम सप्लीमेंट्री एफिडेविट में पूरा नक्शा के साथ लगाया। अब इसलिए जो है
सर एंटिसिपेटरी बिल नहीं होगा, रेगुलर बिल में सुनेंगे आपका पूरा मेरिट। ABA number 270 of 2026. For the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that as per the allegation leveled against the petitioner, who was a Karamchari at the relevant point of time, huge chunk of land in relation to खाता number नहीं withdraw नहीं करना, हमको बाकी में यूज करना पड़ता है ना।
after some argument,
ठीक है, after some arguments, when this court was not inclined to enlarge the petitioner on anticipatory bail, the petitioner seeks permission to withdraw this application. It is dismissed as withdrawn. हम तो ओपन रहते हैं सर, ऐसी बात नहीं। अगर मान लीजिए आप कुछ ऐसा क्लिंचिंग चीज बता देंगे तो ऐसी बात नहीं कि if I don't disclose my mind, how will you address?
No, my lord, since my lord has not been pleased to grant Lord the answer to other person, therefore my lord, you have a view that this is also the same.
My views are the further also. चलिए।
Serial number 9, ABA 932 of 2026.
My lord, if he surrenders, my lord, this case will not be.
Naturally कोई prejudice का कोई बात ही नहीं। Yes, please.
Serial number 10, DA 1093 of 2026.
Regular basis of petition. Within custody since 1 year 9 months.
Date of custody.
Date of custody since 5/8/2024. My bail was rejected in Lordship. My daughter dated 7/8/2025, Annexure 3, page 40 of Lordship. Annexure 3, page 40. There are altogether 22 prosecution witnesses. Charge has been paid to Lordship in this case in the month of January 2025, 4/1/2025. When this bail was rejected on 7/8/2025, at that time out of 22 prosecution witnesses 10 were examined. After that again in 8 months only 3 witnesses were examined. And I have given the date on the last occasion the Lordship has followed the entire record. On the several date of Lordship, that is on 7/4/2025, 21/4/2025, more than 10 or 20 days, no witnesses were examined.
How many witnesses have been examined so far?
More than 9. More than 9 or 10?
How many witnesses have been examined so far?
13.
13 out of 20.
22.
You had also filed an application for recall.
Recall after one of the witnesses.
Right?
Yes, we have filed.
Which the court says that you did not cross-examine at a
On that
particular
day, it
point
was
of
not
time,
cross-examined.
and the delay is attributable to you. And all these
That
things
one
have
day.
been mentioned.
That one day.
One
But
day.
after that,
We will direct examination of all
But
the
you are not being telling
witnesses.
us in my case.
Your husband?
I'm the
Right?
husband.
Yes.
I'm the husband.
You see, the case has been dismissed on merits once.
It was dismissed on merit in the case of credit 4B.
Yes.
The minimum sentence would be 7 years. I
Minimum-
remain. Yes, it is a case of credit 4B. Minimum sentence would be 7 years up to life. 7 years to life. That is not a case of credit 4B. Admittedly, the victim has committed suicide. In one of the paragraph of the case diary, the IO has mentioned, or the investigative officer has mentioned that at best it will be a case of credit 6.
That point was not available to you when you were arguing.
Again, before when I will custody also that I can argue that I can submit to
It's
the
not,
lordship
it's
that
not
it
like
is a case.
once the bail application is rejected,
Yes.
then you can take care
On
of
that
the
day-
subsequent events, maybe the witnesses turning hostile or some other
Custody
development.
or
Or
custody.
yes,
The
we
21
will expedite your
In
trial.
this case lordship में
आप बताइए ना डे टू डे करा दो। अब तैयार हो जाइए। आप तैयार होइए।
हम बता रहे हैं इस केस का एक और फैक्ट बता रहे हैं कि द फादर ऑफ द इन्फॉर्मेंट उनके अगेंस्ट में भी एक सीरियस एफआईआर फाइल हुआ है बाय द एंड लॉर्डशिप हैज गॉन थ्रू दैट अफेयर देयर वाज एलिगेशन दैट द विक्टिम हैज नॉट कमिटेड सुसाइड बिकॉज़ ऑफ us victim has committed suicide and there was every possibility because of torture and ill behavior of her father and that has also been categorically submitted before lordship He is not asked us. Admittedly, I was not present at Ranchi. At the time of occurrence, I was at Saharanpur, Uttar Pradesh. Doctor has said that it is a case of family. There are so many reasons why the victim might have committed suicide. But he only being the husband will actually remain in custody, under trial custody, remain in custody till trial is going.
Or the learned counsel's opinion on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the husband of the victim, whose bail application was earlier rejected.
Earlier it was withdrawn, after that it was rejected on 17th February.
Earlier it was withdrawn and subsequently it was rejected by a coordinate bench of this court. He has submitted that the petitioner has been falsely implicated in this case only because he is the husband. Rather, the victim committed suicide in her matrimonial home on account of torture by her own father. There is another FIR in connection with such allegation. During course of arguments, he has also submitted that the petitioner is in custody since 5/8/2024 and there are 20 charge-sheeted witnesses and only 13 have been examined so far. 22. And only 13 has been examined so far. You are for the informant. The learned counsel for the informant, while opposing the prayer, has submitted that the petitioner himself is taking steps so as to delay the trial, inasmuch as they did not cross-examine one of the witnesses, due to which they filed a petition for recall, and ultimately that petition for recall has also been dismissed. Dismissed हो गया? Yes. Has also been dismissed against.
One application is pending. Another application is pending.
Has been dismissed. She submits that the informant. She submits that she has no objection if there is any observation regarding the expeditious trial of the petitioner, provided the petitioner cooperates with the expeditious trial. The learned counsel for the state, while opposing the prayer, has submitted that the victim died unnatural death in a matrimonial home within 2 years of marriage?
Yes.
Within 6 months of marriage. However, the state is ready to produce the witnesses promptly. After hearing the learned counsel for the parties and considering, this court finds that the bail application of the petitioner was rejected on merits, observing that there was allegation against the petitioner that he was torturing his wife for demand of rupees 25 lakhs and the flat which was standing in her name to be transferred in the name of the petitioner. This court is not inclined to enlarge the petition on bail. However, the state is directed to ensure produce the remaining witnesses without fail. The counsel for the state is directed to communicate this order to the superintendent of police of the concerned district and also to the director of prosecution to ensure compliance. Certainly, the question of expeditious trial of the petitioner would arise only if the petitioner also cooperates with the trial.
Serial number 11, BA 1602 of 2026.
The petitioner is in custody since 18/7/2023. That is nearly
3 years notice for the alleged offences under sections.
What
the
is the
charge.
stage now? What is
The
the stage?
stage is the case is pending for supply of police vehicles. It has come in the June order itself. Now this case was
June order बहुत पुराना है सर.
हाँ, अभी भी वही है 13/11/25 का order. But still, since the other co-accused persons belongs, the investigation is pending. That has come. Now, Lords, this FIR is the predicate offence on the basis of which 2 ECIR cases were lodged by the ED. That is ECIR 1 of 2023 and ECIR 6 of 2023. In those very cases, the petitioner has been granted bail by the Honorable Supreme Court. Lords, I am forwarding the order before your Lordships on the ground of custody.
This is on money laundering. This is the case lodged
This
on money
the
laundering.
present case was the predicate offence on the basis of which this ECIR case was lodged by the ED. The ED has made a raid in the house of the petitioner, who happens to be the revenue inspector, and certain documents were found in his house. Taking into consideration this FIR as predicate offence, those 2 cases under Money Laundering Act was lodged by the ED. Now, so far this case is concerned, it is alleged that on the raid conducted by the Enforcement Directorate, your Lordship may kindly turn to page
See,
30.
huge documents, forged documents have been recovered. But what is the prescribed punishment? Suppose you are convicted. What is the maximum punishment which you can have?
7 years.
Is that so much?
13 BC Act में तो
इसमें 4 से 10 है
10 years.
Prevention of Corruption Act, but there is no such allegation.
Or
So far, the PC Act is concerned, Lord, so far, if at all the allegations are believed to be true that the official documents were found in the house of this petitioner and those were found tampered.
471 is also 7 years.
No, 471 is more.
That is an IPC. IPC
471 is more, Lords.
तो फिर आप कैसे बोल रहे हैं maximum 7 years?
13 में 10 years.
13 की बात नहीं कर रहे. 471 is how much?
471 में अलग से प्रेस्क्राइब नहीं है. फोर्जरी का जो पनिशमेंट होगा, that would be the punishment under 470.
409 is also there.
नहीं, 409 में नहीं.
409.
Charge sheet.
Vigilance case.
Charge sheet. Page 24. Now, forgery is defined under 465 years. The punishment is 2 years. 471, it says that whatever would be the punishment for forgery, that will apply for 470.
आपको 467 हुआ.
467 मेरे ऊपर अप्लाई नहीं करेगा. In view of the fact, Lords, may kindly have a look to 466. 466 and 467 cannot apply side by side because both are distinct offences. If your Lordship may kindly come to 466.
नहीं, you see, I am not inclined. It's very serious.
Lords,
I'm
the
not
custody
inclined.
may be taken
We will
into
take
account.
into consideration और आपको जो मन हुआ करिए, लेकिन I am not inclined.
एक बार 466.
हम देख लेंगे. Heard the learned counsel is appearing on behalf of the parties. The learned counsel for the petition submits that arising out of the same day, two ECIR case bearing number 1 of 2023 and 6 of 2023 were instituted by the Directorate of Enforcement under Section 3 and 4 of the Prevention of Money Laundering Act. And on the ground of custody, since 14/4/2023, the petitioner was enlarged on bail ultimately by the Honorable Supreme Court. He submits that so far as the present case is concerned, the maximum punishment could be 7 years. He has further submitted that once the petitioner has been enlarged on bail in BCIR case, there can be no reason to refuse the bail of the petitioner in the present case. The case is pending
For supply of
for
police.
supply of newspaper, and the petitioner is in custody since 18/7/2023, and he is the revenue inspector. The learned counsel for the state has opposed a prayer and has submitted that the petitioner was found in possession of 17 registered two in several volumes and land records and deeds kept in 11 trunks in his home, and several registers and records were found tempered, and the petitioner is an accused. He is an accomplice in falsification of original records of several genuine landowners and to create bogus reports. She has submitted that it is not correct to say that the maximum punishment could be 7 years. Rather, PC Act is also involved where the prescribed punishment is up to 10 years, and under section 467 of IPC, the maximum punishment prescribed is imprisonment for life. To which the learned counsel for the petitioner has submitted that 466 and 467 cannot go simultaneously, and petitioner is also an accused under section 466, and therefore the maximum punishment under 466 is 7 years. After hearing the learned counsel for the parties and considering the serious nature of allegation against the petitioner, as indicated by the learned counsel for the state, this court is of the considered view that mere custody of the petitioner is not a ground to release the petitioner on bail in the present case. Accordingly, the bail application of the petition is hereby rejected. However, the state is directed to ensure that there may not be any delay in the trial of the petitioner. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the Director of Prosecution, so that the police papers are supplied immediately and the court may proceed. The state shall also produce the various witnesses promptly.
Serial number 12, BA 1681 of 2026.
Regarding of the case number 25, petitioner is one of the seven power of attorney.
Is he the vendor?
He is the vendor, but his case is distinguishable. Kindly just come to my counter affidavit. But he had sold 3 pieces of land. I am not disputing para 9. Okay, what is missing? 10. Kindly come to 13. But this land which he had sold, Madam, I I read para 13?
Yes, yes.
That further during the course of investigation, it was revealed that from bare perusal of sale deed by which petitioner, along with others, sold 28 decimals of land situated over so and so to Vinay Kumar Singh and Srikta Singh, it was revealed that the seller of the said land, Bhagwan Prasad Gupta and others, including the petitioner Indra Dev Prasad through their power of attorney holder. However, from the correction slip issued in favor of Vinay Kumar Singh and Srikta Singh, it was revealed that the seller of land in question of Bhagwan Prasad Gupta and others versus Jamabandi Raiyat of Mauja so and so still stands recorded in the name of Pradeep Kumar Jain and Rajesh Kumar Jain, both sons of Kishan Lal Jain. As per registered
So
to
they had no title.
no title, but kindly see page 36 of the FIR. But in fact, this kind of land scam is happening. But we are investigating now a case in Ranchi with respect to rings, and we have found that these lands pertaining to rings for false title deeds are being created, everything, and we have arrested 2 sellers. Kindly see page 36 of the sale deed here. But this is the FIR. Sale deed is annexed. His name is at serial number 4, Indra Prasad Gupta.
Page number 36.
36
Serial number 4.
Yes, serial number 4. His name is Indra Prasad Gupta. And they had described themselves that they had got the property through their ancestors, and it was recorded in the name of their grandfathers and all. And this is how they sold the land. And whereas it has clearly come in our case diary that the mutation was standing in the name of one Rajesh Jain in 1984-85. And her ladyship has considered this for my submission in Vinay Kumar Chaube, which I specifically made. So this
He is the vendor of the same property.
same
Vinay
Kumar Singh and Srikta Singh. Apart from other properties, but other properties we could not get any, but this we have got specific details. And that details are mentioned in our case diary, para 300 and 306.
Now, ladyship, can I place the case on merits? If it's disputing my title, the ladyship may kindly take my supplementary affidavit. We have purchased this
I
land.
just want to know from you. Okay, he has fraudulently sold the property standing in the name of somebody else. But the point, the entire allegation in the present case is that Vinay Kumar Chaudhary, the circle inspector, the circle officer, etc., they connived together to get these properties mutated in the name of the purchaser.
But the mutation which has been done, it's not that the only role of the purchaser is there. But in cases where the sellers have also connived with the records and then got the sale done and the mutation done. So here where the connivance with respect of the sellers are also writ large in respect of this 28 decimals of land.
So before the sale deed, the petitioner got his mutation done.
Well, that's what we are saying. As per our records, the mutation was in the name of Rajesh Kumar and somebody.
Jain.
Jain.
Yes. Did they get the mutation done in their name?
Well, that it has not come around in our record. It was in investigation. It has come that it is still standing in
That's
there.
right. It's the mutation is standing in their name.
In fact,
These petitioners who claim to be the owner of the property.
yes,
Right. The buyer never verified whether the mutation is standing in the name of this petitioner or not.
yes.
Right. So what role does he have? He has not got the property mutated in his name
But
and he sold it to somebody.
But that's what I'm saying. Kindly come to page 54 of the FIR also. I'm just showing how the mutation is being done.
This is anticipatory bill.
No, regular way.
Page 50.
Page 54. Here also it is recorded. जामाबंदी रैयत का नाम प्रदीप कुमार जैन, राजेश कुमार जैन, so and so.
Yes.
And विक्रेता का नाम भगवान प्रसाद गुप्ता, ईश्वर चंद्र गुप्ता, son of so and so. Without any mutation being in their favor, they have got the land for. But I am aware of the principle. The buyer be aware of.
You see, if the buyer does not take care, in whose name the mutation is standing, he goes, takes the money. The seller goes, takes the money, whatever he thinks that he has a right. You see, there is no scope for the registry office to verify whether there is a mutation. There is no scope for the registry office to go into it. Registry office will, otherwise if there is no impediment, registry office will get the property registered. You do not have even a list, whatever list was there in the mutation.
That's missing, madam.
That is also not there in the registry office. Had you given that list in the registry office that these are the properties which are not required to be sold also. Let us see for a moment. That is also not there. A person believes that he is the title holder. He knows that he has not taken any steps to get the property mutated in his name. Had he done it, then I can understand that there is some connivance. And ultimately what happened, the buyer got the property mutated irrespective of the fact that it was standing in the name of somebody else. And then ultimately the mutation is
But though, madam, correctly, our case is made out on the mutations done
That's
in
right.
2011.
So what role this particular seller has got? He has not done anything. So far in the entire mutation he has done nothing.
In that mutation, he has not done
Nothing,
nothing, but
no,
the entire
no.
transaction has
You
which
see,
has
if
taken.
you say that he has a role, then your case against
We have to
others
go
will be weakened. You see, you have made out a case in your FIR that the mutation was done under the instructions of Vinay Kumar Chaubey, and the record showed that mutation should not have been done. Right? And the property was standing in the name of somebody else. Somebody else has sold the property. मल्टीपल सेल रेट प्रॉपर्टी का कितना मिलता है कि
तो एक फ्लैट का 5 बार सेल हो
5 बार सेल हो जाता, अलग अलग आदमी सेल कर दिया. आपका रजिस्ट्री ऑफिस में तो कोई बैलेंस चेक एंड बैलेंस है नहीं. there is no such concept कि वहाँ रजिस्ट्री ऑफिस में चेक होगा. टाइटल भी नहीं चेक होता रजिस्ट्री ऑफिस में. आप जो प्रॉपर्टी मन हो वहाँ पर अपना कहाँ.
As the leadership I just indicated.
That's it. I will record whatever you have indicated.
Otherwise, petitioners, yeah, sister saying they mutated. I have filed my supplementary affidavit, but your leadership has already passed an order with regard to seller.
Yeah. Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the owner of the property which has been sold, and the entire history with regard to the title of the petitioner has been mentioned in the bail application. He has submitted that as per the allegation, the mutation was done in the name of the purchaser, irrespective of the fact that the Jamabandi was standing in the name of persons other than the petitioner. He submits that the petitioner believed that he has title over the property and has sold the same, and admittedly mutation was not running in the name of the petitioner.
It was run in the name of ancestor of the petitioner. I have filed a supplementary
He
affidavit.
submits that it was, as per the allegation.
As per the allegation.
As per the allegation, the mutation was not running in the name of the petitioner, and therefore the petitioner has got no role to play in the matter of mutation, which is said to have been done in connivance of the purchaser and the other officials of the state government. He has submitted that at best it's a case of title dispute, and mutation by itself does not create any title. The learned counsel for the state has opposed the prayer and has submitted that the property which was sold did not belong to the petitioner. Rather, as per the records, revenue records, it was belonging to Pradeep Kumar Jain, Rajesh Kumar Jain, and the mutation was running in their name. And therefore, the role of the petitioner cannot be denied. To this, the counsel for the petitioner has referred to order dated 23rd of April 2026 in BA number 927 of 2026, and submits that in the same case, the vendor of the property has been enlarged on bail whose case arises out of the same FIR. Same FIR.
Same FIR, and ये जो petitioners है, this 927,
They are my vendors. Their ancestors were my vendors of my ancestors.
He submits that the petitioners who have been enlarged on bail in BA number 927 of 2026 were the vendors of the present petitioners.
मतलब इनके जो ancestors थे, they were vendors of my ancestors.
Sorry, the ancestors of the petitioners in BA number 927 of 26 were the ancestors of were the vendors of the ancestors of the present petitioner. After hearing the learned counsel for the parties and on the face of the record, it appears that the Jamabandi was running in the name of Pradeep Kumar Jain and Rajesh Kumar Jain. Although the petitioners sold the property and ultimately, as per the allegation, the purchaser of the property connived with the government officials to get the name mutated in their name. Although the revenue record was not standing in the name of their vendor. In view of the aforesaid facts and circumstances, and this court is of the view that in view of the aforesaid facts and circumstances, the co-accused having been enlarged on bail, the petitioner is also directed to be enlarged.
Serial number 13.
Charge sheet has been submitted. That can be mentioned.
And charge sheet has already been submitted.
BA 2488 of 2026.
Conditions were on the same basis.
Same. और क्या इनका वो पासपोर्ट वगैरह जमा
वही जो
वो
पुराने
स्टैंडर्ड है. Yes, please.
This case allegation is that the petitioner forced the victim to send pictures on Instagram and create an Instagram account and send pictures to someone, posted those pictures. The logically sections that has been put in is 70 pages, corresponding 354. The logically must be made out under that section.
No case is made up. What do you say? No case is made up.
Earlier,
You have got the, you see, the.
Earlier, they crossing the direction to the Instagram's account and
Yes.
report. I filed the counter.
That report is there.
Yes,
Yes, and
But
exactly.
you have used it is your Instagram account.
Yes.
Your Lordship,
What else is required?
Your Lordship is also in custody since 22/11.
22/11. और क्या स्टेज है केस का? What is the stage? Charge frame?
Yes, Your Lordship. Charge has been framed on 31/2026.
1-3.
30. 31/2026. Your Lordship, also medical has been denied by the
Avoid the learned counsel counsels appearing on behalf of the parties. The counsel for the petitioner submits that the petitioner is in custody since 22/11/2025 and he has been falsely implicated in this case. However, the charge has already been framed on 31/2026. As per the allegation which has been, the case has been instituted on the basis of written application alleging that the sister of the informant and the petitioner are friends through Instagram, and the petitioner threatened and pressurized the sister of the informant and asked her to send photos. And later on, when she denied to talk, the petitioner made viral those photographs through his Instagram portal to friends and relatives of informant's sister. And he also tried to threaten the sister of the informant when she was going to college and tried to outrage her modesty and threatened to commit rape upon her and kill her. The Council for the State has referred to the order dated 8/4/2026 and has submitted that it was indicated by the Council for the Petitioner on that day that the petitioner was not the Instagram user, and in the counter affidavit, the materials have been based on record, which indicate that it was the petitioner who was the user of the Instagram account through which the video/photograph got made viral. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, and it has also been found that the petitioner was the Instagram user through which the alleged obscene photographs of the victim has been made viral. This court is not inclined to enlarge the petitioner on bail at this stage.
Serial number 14, BA 2650 of 2026.
This petitioner.
Serial number 14, BA 2650 of 2026.
Where is the petitioner?
Informant is himself victim. All the FIR for financial fraud of 1,90,000 that is transferred in account of this petitioner.
Petitioner absent. Goes to
Serial number 15, BA 2693 of 2026.
क्या बोल रहे हैं सर? At the request of the Council for the State, post this case on Tuesday this afternoon.
Serial number 16, BA 2751 of 2026, along with serial number 17 and 18.
The case of cybercrime laws, and from the position of this petitioner, there is a
कोर्ट में ही डायरिया एक सेकंड दे दिया
तो ओवर करते हैं आप देख लीजिए 12:30 बजे टेकअप करते हैं उनको दे दीजिए पूरा पूरा बंडल दे दीजिए ठीक है 1 बजे 1 o'clock.
Serial number 19, BA 2756 of 2026, and serial number 20, 21 and 22.
ये 20 में भी आपको केस डायरी चाहिए
राइजिंग आउट ऑफ सेम पीएस
इसी से 1 बजे करते हैं इज दैट ओके
Serial number 23, BA 2757 of 2026, and serial number 24 and 25.
Yes, petitioner. Are you there in this case?
24 years I have get.
This is 2757.
उसको भी एक बड़े कर 2758.
2757 में तो एक एंटीसीडेंट है. चलिए कोई बात नहीं, एक मिनट. उन्होंने अपने पिटीशन में ही बोला. पिटीशन में ही बोला.
Serial number 26, BA 2762 of 2026.
Petitioner.
Serial number 26, BA 2762 of 2026.
Yes, read the FIR. FIR पढ़ी. पढ़ी FIR.
पेज नंबर 50. निवेदन है कि मैं जितनी देवी
नाम मत बताइए.
पति स्वयं सो कारोटी बहराबाद थाना जंगल जिलागिरी निवासी हूँ. मेरी नाबालिग पुत्री स्वयं सो एक कोग्राम में आशीष पूरी पिता साजिश के तहत बहला फुसला कर भाग कर ले गया है. इस संबंध में कारापुरुषी ने अपनी बहू बनाने के लिए मेरी बेटी को भगाया है और वह हमें आशीष मेरी बेटी उसी ने अपनी बहू बनाने मेरी बेटी को भगाया है. वह हमें भी बेटी को साथ घर में रखे हुए 20,000 रुपया नकदी सिकड़ी सोने की नचिया को लेकर के भाग गया है. अशोक पूरी आए दिन हमारे साथ गाली गलौज लड़ाई झगड़ा कर रहा था और काफी धमकी दे जैसे तुमने पुलिस पर केस मुकदमा किया तो हमारे पूरे परिवार को जान से मार देगा, उठवा लेगा. घटना के संबंध में रिश्तेदारों से काफी बदनामी हो रही है. हम मानसिक रूप से अत्यंत प्रताड़ित हैं. ऐसा श्रीमान से करोड़ प्रार्थना है कि दोषियों और आशीष के विरुद्ध धाराओं के तहत मामला दर्ज कर मेरी नाबालिग को जल्द से जल्द बरामद करने दोषियों को कृपा करें ताकि मैं सदैव आभारी हूँ. Earlier, my lord, call for the case diary and a statement of the victim recorded under 183 of BNC.
कहाँ है 183 का स्टेटमेंट?
स्टेटमेंट हमारे हुजूर मंगाए थे. Age of the victim, my lord, 17 to 18. Between my lord 17 years to 18 years. वन 180 का स्टेटमेंट है मेरे पास में. मैं परमिटेड टू रीड, my lord.
एक सेकंड.
पैराग्राफ नंबर 30.
एक सेकंड. एज ऑफ द विक्टिम कहाँ से बोल रहे हैं? 17 to 18 years.
मैडम इसमें एज पर जो सर्टिफिकेट आया है, सर्टिफिकेट का मतलब है
आया
पैरा
1249 ऑफ केस है.
और 49 में आया है. पैराग्राफ नंबर 49 में डेट ऑफ बर्थ आया है 30/11/2008.
डेट ऑफ इंसिडेंट कब का है?
10/1/2026
आपको क्या? You are the informant. You are the informant.
This is a minor girl, 17 years, what that is.
But her statement is that she eloped and got married. BA number 2762 of 2026. The learned counsel for the petitioner submits that the petitioner is 18 years of age and the victim was more than 17 years on the date of the alleged offence. He has submitted that there was love affair between the parties and no criminality as such is involved. However, the charge sheet has been submitted. The petitioner is in custody since
My lord, 21/1/2026.
21/1/2026. The learned counsel for the state as well as the informant have opposed the prayer for bail. However, the facts stated by the petitioner is not in dispute. The statement of the victim has also been placed on record, which reveals that the victim was having an affair with the petitioner and she eloped with the petitioner and married him. Considering the fact that charge sheet has already been submitted and the statement of the victim and also the age of the petitioner is directed to the enlargement.
Serial number 27 BA 2775 of 2026.
The matter was, we have heard, his diary was also and also he was arrested. In fact, counter affidavit has not been filed in this case.
I'm getting
This case has been registered in section 103, one of the means.
Yes.
Not the case of dowry death, rather this case allegation with regard to committing murder, 103 that is murder. See, as per the case of the prosecution that the marriage was solemnized on 15/7/2025. And the alleged organs had taken place in the month of November 25, that is after 4 months of marriage. As per the allegation, first information report, the allegations have been leveled that there was a demand of rupees 6 lakhs and a golden chain, and due to non-fulfillment of the demand, she was being tortured at her waiting room. And the accused persons have committed her murder, and then information was given to her, and she came and seen the dead body. During investigation, some important facts have been brought have come. During investigation, for that, I would like to place the statement of two of the important witnesses, Savannah Bibi and Harun Bibi.
Para number?
It's the last page, the paragraph 37 and 38 of the case letter. I am placing the statement of these two witnesses.
Who are they?
They are the neighbors. They are there. There are two sets of the witnesses. First one from the side of the.
And you are the husband?
I am the husband. Even I was not present at the time of occurrence when she had committed suicide in the house. At first I am placing the statement of Savannah Bibi. She says, आगे बताइए कि 23/7/25
Just a moment. Statement.
लास्ट में वो अलग से करके
यस बताइए।
सवाल आती सीसीज 23/7/25 को सुबह 9:45 बजे गांव के बगल तालाब के किनारे वाले खेत में धान बांध रही थी तथा बगल के खेत में खैरून बीबी पति सचिन सच ने खेत में धान बांध रही थी। तब हम लोग अपने खेत में धान बांध रहे थे तो पूर्वा खुद मदरसा से पढ़ाई कर अपने अपने घर जाने वाले बच्चे हल्ला करते जा रहे थे कि रशीद दादा की छोटी बहू फांसी लगा ली है। फांसी लगाने की बात को सुनकर रशीद अंसारी बच्चों से पूछे तुम लोग क्या बोल रहे हो। रशीद अंसारी पूछने पर बच्चों ने बताया कि अपनी छोटी बहू सोने वाले रूम में फांसी लगा ली है। फांसी लगाने की बात सुनकर हम सभी खेत से भागकर मुबारक अंसारी के घर आए। दरवाजा खोलने का प्रयास किया तो पता चला कि दरवाजा अंदर से बंद है। इसके बाद हम लोग खिड़की से झांक कर देखे तो देखे कि मुबारक की पत्नी पंखा में फांसी लगा ली है। मुबारक अपने मोटरसाइकिल में पेट्रोल पंप से पेट्रोल भराने के लिए गए हुए थे। वे मोटरसाइकिल से भागते हुए आए। It's also important. I was not there. और दरवाजे पर जोर जोर से लात मारा। लात मारने पर दरवाजा खुल गया। दरवाजा खुलने पर हम लोग फंदा को काटकर सलेखा को सुलाए तो सभी बोलने लगे भी जिंदा है। इसके बाद मुबारक अपने अन्य लोगों के साथ अपनी पत्नी को टेम्पो में लेकर डॉक्टर के पास ले जाने लगा। जब मुबारक अपनी पत्नी के साथ पूर्वापुर करबला तक पहुंचे तो पूर्वापुर के लोगों को ढूंढने लगे कि लड़की जिंदा नहीं है। इसके बाद सभी लोग टेम्पो के साथ वापस घर आ गए और मुबारक अपनी पत्नी को हॉल में सुला दिया। इसके बाद मुबारक अपने ससुराल में पत्नी के इंतकाल के बारे में बताया। मुबारक के ससुराल वाले जब मुबारक के घर आए तो मुबारक के परिवार वाले को आग लगाकर जान मारने की बात करने लगे। आग लगाकर जान मारने की बात सुनकर मुबारक के घर सभी लोग भाग गए। अभी कहा नहीं कर सकते हैं इस संबंध में कोई जानकारी नहीं है। अन्य कोई व्यक्ति ये बात नहीं बताया। First is try to next the witnesses marks. Harun Bibi, her statement is also similar. He also says कि मुबारक अपने मोटरसाइकिल में पेट्रोल पंप में पेट्रोल भराने के लिए गए हुए। He also says कि हल्ला सुने उसके बाद आए लेकिन फांसी लगाने के बाद सुनकर रशीद अंसारी बच्चों से पूछे क्या हो रहा है। रशीद अंसारी के पर बच्चों ने बताया कि अपनी छोटी बहू सोने वाले कमरे में फांसी लगा ली है। दिस इज द स्टेटमेंट ऑफ हैरून लगा ली है। फांसी लगाने की बात सुनकर आए सभी लोग खेत से भाग कर आए और दरवाजा खोलने का प्रयास किया तो पता चला दरवाजा अंदर से बंद है। इसके बाद सभी लोग खिड़की से झांक कर देखे तो पाए कि मुबारक की पत्नी पंखा में फांसी लगा रही है। मुबारक अपने मोटरसाइकिल में पेट्रोल पंप में पेट्रोल गए हुए थे। वे मोटरसाइकिल से भागते हुए घर आए और दरवाजे पर जोर जोर से लात मारा। दरवाजा खुलने पर दरवाजा खुल गया। दरवाजा खुलने पर हम लोग फंदा को काटकर सलेखा को पलंग पर सुलाए तो सभी लोग बोलने लगे कि अभी जिंदा है। इसके बाद मुबारक अन्य लोग के साथ पत्नी को टेम्पो में लेकर डॉक्टर के पास ले जाने लगे। जब मुबारक अपनी पत्नी के साथ पूर्वापुर करबला पहुंचे तो बोलने लगे कि लड़की जिंदा नहीं है। इसके बाद सभी लोग पेट्रोल पंप टेम्पो के साथ घर वापस आ गए। मुबारक अपनी पत्नी को हॉल में चौकी में सुला दी है। इसके बाद मुबारक अपने ससुराल में पत्नी के इंतकाल के बारे में बताया। मुबारक के ससुराल जब मुबारक के घर आए तो मुबारक के परिवार वाले को आग लगाकर जान मारने की बात करने लगे। Then statement of one another witness Rajendra Prasad is also important.
क्या बताना चाह रहे हैं सर?
Yes, from the statement of Ganesh.
Charge has been framed only under section 103.
Yes, sir.
Dowry Prohibition Act नहीं है?
Dowry 3-4 का उसका होगा।
होगा ना?
I am not sure about the inadmissibility.
How are you not sure? You should not have made a statement if you are not sure.
The charge has been framed under which section? For that I am not sure. I am
Then
not
why did you make a statement?
Charge has been framed.
For the learned counsels appearing on behalf of the
But the
parties.
postmortem report is also
Not
important
required.
in this case.
Not
Postmortem
required.
report, because the cause of death, that is
Wait,
important.
yes.
How she died.
Wait.
अगर वो होगा उसको rectify कर देते हैं, if any wrong statement has been made by me, then I
It
should
doesn't
be.
make any difference, sir. The learned counsel for the petitioner submits that the petitioner is the husband and his wife committed suicide by locking herself in the room. At the time of commission of offence, the husband had gone to get petrol in his vehicle, and when he came back, when he came to know, and he immediately came back and pushed the door to open it, and ultimately, and it was opined by the people around that the victim was alive, and the petitioner immediately took her to the hospital and she was found dead. The learned counsel submits that the petitioner has no role in the matter and the victim had committed suicide. The learned counsel for the state here for the informant, and the informant has opposed the prayer for bail and has submitted that within 5 months of marriage, the victim committed suicide and there is a clear allegation of demand of dowry in the FIR itself. After hearing the learned counsel for the parties and considering the fact that the victim has committed suicide in a matrimonial, was found dead in a matrimonial home within 5 months of marriage, and there is clear allegation of demand of dowry, this court is not inclined to enlarge the petition on bail and reject it.
Charge has been framed under section 82 of BLS.
82
of BLS.
Serial number 28. That I have not mentioned my petition. The charge has been included. Also, there is no mention in that charge.
Serial number 28, DT.30.04.2026 of 2026.
Under section 96 of BLS, that is the protection of the child. In this, the informant is the mother of the girl, and she has stated in her FIR that the girl had gone on her own to a wedding house, and she was waiting for her parents at the shop called Chandni Shop, where after saying to the children that pani pi ke aate hain, she had left and not returned back. And after 5 days, the FIR was lodged, and it has also come in the FIR that Facebook पे ये लड़का जो मुन्ना शिद्दा the petitioner had posted a photograph of a girl. So that's why they had scolded him, and this case was lodged against this petitioner.
Where is her statement under section 183?
180.
183.
183. The case ready was for last statement. 180 पे कोई physical relation नहीं बना है, वो उन्होंने नहीं दिखाया. It is minor. हाँ, minor is there. The age is around 13 years and the boy is around 19 years. वो चौक पे वो मिल गया, वो statement उनको दी.
उनका statement कहाँ है?
पैरा 45 में CD में वो
22 लास्ट पेज में सेपरेट सी
पढ़िए जरा, नाम मत पढ़िए.
थैंक्स सर. 13/10 बता का है पुष्पा अपने के द्वारा बताया कि हम आज तक पढ़ाई उच्च विद्यालय बांका से पढ़ी हूँ. मैं दिनांक 9/4/25 को समय करीब 5 बजे घर से अपने घर से छुट्टी बहन के साथ बहादुर शादी के घर जाने के लिए जब हम चांदी चौक पहुँचे तो मुझे मुन्ना शर्मा जो हाथ बांका का है मिल गया. मुझे अपने साथ जाने को कहने लगा कि हम अपनी छोटी बहन को वहीं और छोड़कर पानी पीने बोलकर वहाँ पे चले गए. जिसके बाद हम दोनों देवघर में लखनऊ चले गए. वहाँ पर स्टेशन के बाहर सोए हुए थे. वहीं पर मुन्ना शर्मा सोते हुए छोड़कर उसका मोबाइल लेकर भाग गए. जिसके बाद हम ट्रेन पर बैठ गए. इसी तरह ट्रेन में घूमते हुए प्रयागराज जंक्शन पहुँचे, जहाँ से हम घर फोन किए और फिर पापा के दोस्त मुझे ट्रेन बैठा दिए, जिसके बाद मुझे धनबाद से मेरी मम्मी पापा गोंडा स्टेशन ले गए, जहाँ से पुलिस के साथ थाना आया। लड़का मुझे पहला फुसला कर ले गया था, वो मेरे साथ शारीरिक संबंध नहीं बनाया था, यही मामला। Petitioner have a two criminal accidents.
Sorry?
और चोरी का है। Petitioner have a two criminal accidents. फोन चोरी का मोटरसाइकिल चोरी का है। चार्जशीट has been charged and also been framed.
क्या चीज चोरी का?
वो बाइक चोरी का सीसी में आया है और फोन चोरी।
बताइए जरा कहाँ?
गुंडा कांड संख्या 134/2024 and गुंडा कांड संख्या 102/2021 रजिस्टर्ड अंडर सेक्शन 370 surplus 4 375 303 35 3 surplus 5 DNS and minor 380 411 440 457 24 acts.
Nothing to do with any girl child or ladies से related कोई offence नहीं.
The age is also 19 years old.
वही तो 19 years की उम्र में 3 केस कर लिए.
And it has come that love relation का वो लेके गया.
Love relation तो नहीं आया मैडम.
It has come in the confessional statement. वो लेके गया उसका वहाँ गया उसको रूम लेके.
Confession statement को आप अपने मन से जब मन होगा यूज करिए, जब मन होगा यूज मत करिए, ऐसा तो नहीं होता.
The girl has said.
The girl has not said that there was any love affair.
In the statement is
No. That अभी तो पूरा ही statement है. Love relation का कोई बात नहीं होगी.
उसको जानती थी और उसके साथ उसके चली गई, बट शी हैज प्लान्ड कि हमको जाना है देवघर और वहाँ से लखनऊ और लखनऊ से फिर वापस उसको सोते हुए छोड़ के वो फोन लेके भाग गई अकेले. मतलब लड़का ले गया है या प्रेशराइज, और इसमें भी आया कि देवघर मंदिर में शादी भी किया है एज पर अर्लियर स्टेटमेंट आल्सो सीडी में आया हुआ है.
किसका अर्लियर स्टेटमेंट?
इसी में आया हुआ है
भाई आपसे ज्यादा सीडी उनको पता है. बताइए जरा सीडी में क्या है. एक्यूज को सीडी के बारे में ज्यादा जानकारी है. दीजिए जरा आपको सीडी पढ़ने. कौन से स्टेटमेंट में आया है शादी करनी है तो और ज्यादा सीरियस है.
हाँ वो देवघर में वो खुद बोली है कि हम शादी.
कहाँ बोली है? कहाँ बोली है? किसके इंस्ट्रक्शन पे आप बोल रहे हैं? उनके स्टेटमेंट में तो है ही नहीं. Which paragraph? Call for the statement of the victim recorded under section 183 BNSS. Then, I will need this statement. 183 का statement से लिखिए. Post on 12th.
Serial number 29, DT.30.04.2026.
Section 64 corresponding to 376 of the RPC. In this case, not safe. The entire allegation appears to be false and concocted. That there is ordinary delay of 2 years in lodging the FIR laws. And now the petitioner is solemnized marriage with the informant on 24/2/2023 lawsuit, which is much before the alleged date of occurrence lawsuit 24/2 that I have annexed and accepted to page 19 lawsuit. That he has also given a birth to a child. And now petitioner is still willing to resume his conjugal life with the informant lawsuit. And so far age is concerned, not say that is her age is, he herself is stated 17 years, but the actual age is more than 18 years. Not say there is not there is no any document to the age of the victim. Not say 17 years he has stated.
They belong to the same community.
Or belong to.
Another career also.
That I am that निकाह नामा है उससे आप जो इसमें हम अभी भी रखना चाह रहे हैं. अगर इन्फॉर्मेंट को अगर
आप शादी किसी से कर ली,
शादी कर ली है, ये आया मुझे, बट ये डिनाई कर रहे
करना चाह रहे हैं तो क्या
ये डिनाई कर रहे हैं. मेरा बच्चा भी है इसलिए हम बोल रहे हैं. मुझे लगा
तब शादी क्यों करेंगे?
शादी हम नहीं किए हैं, हम तो बोल रहे नहीं किए हैं. ये आया है. हाँ आया है.
आप कौन है? इंफॉर्मेंट
No.
इंफॉर्मेंट कौन है? इंफॉर्मेंट को कर देते हैं
हाँ नोटिस कर देते हैं और जो आप सामने में हम ले जाएंगे यहीं से क्योंकि
और
मेरा
183 का स्टेटमेंट
पार्टी नहीं बनाया जो मैं
नहीं, they will, the state is directed to serve notice upon the informant of the case and file affidavit of service. Office is directed to call for the statement of the victim recorded under section 183 BNSS. And also call for counter affidavit for the case diary. ये जो आप बोल रहे हैं कि व्यक्ति का जन्म हुआ है 20/9/2024 को, इसके लिए आपको कुछ एफिडेविट फाइल करना पड़ता है।
एफिडेविट हम कोर्ट में भी जब डायरी होगा तो
नहीं, आप कुछ
हम
एफिडेविट फाइल
दे
किए।
देते हैं मेरी बेटी ये हम लिखे हैं that I have stated para 10 and 11.
The order passed by this court on 7th of April 2026 has also not been complied
I have
by
filed
the.
supplementary affidavit.
लेकिन उसमें ये बात तो नहीं लिखी है।
बच्चे के बारे में।
तो जो भी एक सप्लीमेंट्री फाइल करने से थोड़ी हो जाएगा। Has not been complied by the petitioner in terms of that order, though a supplementary affidavit has been filed. Post on 14th May.
Serial number 30 BA 2789 of 2026.
मेरा
Passover के समय होगा।
स्टेट
Counsel for the petition seeks permission to withdraw this.
Serial number 31 BA 2790 of 2026.
On the last occasion, your office was pleased to call for an incident report and also directed the affidavit as after affidavit.
डायरी रिसीव कर लिया और उसके बाद मेरी क्लास
बताइए क्या बोलना है?
Yes, sir, this is a case of cyber crime and
Antecedent है आपको?
antecedent no antecedent notes. I have also stated in my petition in paragraph number 10 and in the case diary also para 49 it has come that there is no antecedent of it.
Victim है? Victim है?
No
आपको
victim-
सुनेंगे खाली
no-
preliminary चीजें सुनो।
No victim has been examined in this case. Only
No victim has been identified.
No victim has been examined as a witness in this case. Only the IO and the informant, both are the police officers. They are the only charge sheet witnesses in this case. And charge sheet has also been submitted on.
आपसे पूछ रहे हैं केस डायरी में कोई विक्टिम है कि नहीं?
Victim का नाम तो लिखे हुए FIR में नहीं है victim का description.
अच्छा एक बात बताइए, चार्जशीट में अगर किसी विटनेस का नाम नहीं हो तो प्रोसिक्यूशन प्रोड्यूस नहीं कर सकते, क्योंकि विक्टिम अगर आइडेंटिफाई हो जाता है एंड इन द चार्जशीट particularly when the investigation is going on, ऐसा नहीं है ना कि इन्वेस्टिगेशन खत्म हो गया, चार्जशीट तो कर देते हैं क्योंकि नहीं तो आपको डिफॉल्ट बेल हो जाएगा, इसीलिए कर देते हैं।
तो इन्वेस्टिगेशन कंप्लीट करने के
चलते
बाद
रहता है इनका इन्वेस्टिगेशन इतनी आसानी से खत्म थोड़ी होगा। 100, 200, 500 लिंक रहते हैं, हर एक को इन्वेस्टिगेट करने में टाइम लगता है। आपका 90 डेज में नहीं होगा इन्वेस्टिगेशन। ठीक है, आपका कोई एंटीसीडेंट नहीं है एंड नो विक्टिम हैज बीन चार्जशीटेड, जो वो चार्जशीटेड विक्टिम नहीं
charge-sheeted victim name
एज अ विटनेस।
and custody since 5/12/2025.
क्या बोलना है आपको बताएं?
What's it in para 22 of the case diary?
मेरे पास नहीं है, मेरे पास नहीं। बताइए।
इसमें एक किधर एंटीसीडेंट उसको मिला,
एंटीसीडेंट है,
एक एंटीसीडेंट there are several victims found and इनके पास से जो चेक पाया गया उससे रिलेटेड अकाउंट में
क्या नाम है?
आयुष घिरा हुआ है क्रिमिनल एंटीसिडेंट।
Or the learned counsels appearing on behalf of the
May
parties.
I submit one thing, but it is not clear from this that the petitioner has been named or is implicated in this
इस
case.
संबंध में पुणे साइबर थाना कांड संख्या 754
That has been
dated 27/7/2024
Yes.
दर्ज।
But इसमें accused है कि नहीं है petitioner, that is not.
आपको तो खोज रहे होंगे ना वो लोग, अब इनको पता चल गया, अब आपको पकड़ेंगे, नहीं तो आप एंटीसिपेटरी बेल फाइल करिए वहाँ पे। अभी दूसरे जगह पर आपको एक्यूज बनाएंगे तो आपको खबर कैसे, आप खबर लग गया ना आपको।
तो सभी victims का तो नाम इसमें आया है, कानपुर का, कहाँ
हाँ, लेकिन एफआईआर एक में लॉन्च हुआ है,
FIR इसमें।
और अगर मान लीजिए ये चीज गलत हो तो आप आइएगा तो दोबारा आपको भेज देंगे। If this statement is found incorrect, you can come again, right? Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that, as per his knowledge, the petitioner has no criminal antecedent, and charge sheet has been submitted, but amongst the charge sheeted witnesses, no victim has been mentioned. The learned counsel for the state has opposed the prayer and has submitted that, as per the case diary, there is a criminal antecedent against the petitioner, inasmuch as a criminal case has been instituted in Pune Cyber PS case, which is Pune Cyber PS case number 754 of 24 dated 27/7/2024, and in paragraph 22 of the case diary, the numerous persons who are the victims have been enlisted. He submits that अभी investigation चली रहा है. He submits that the investigation is already going on with respect to the other points, though the charge sheet has been submitted. After hearing the learned counsel for the parties and upon going through paragraph 22 of the case diary, and the fact that the petitioner has a criminal antecedent and numerous transactions, and the various victims have been enlisted in paragraph 22 of the case diary, this court is not inclined to enlarge the petitioner on bail.
Cell number 32, BA 2796 of 2026.
Case registered when sections are 103 of the BNSS and 34 of
How are you related to the
the husband, the deceased husband has been implicated in this case. The marriage took place 13 years ago. I have a daughter, 13 years, 32, she was 13 years old. The allegation is that there were quarrel between the deceased and the he, and subsequently she was hurt. In the postmortem report, it has come that the injuries which were inflicted on the deceased were not sufficient to cause death. The reason cannot be assigned because the FSL report was not received yet. But on perusal of para 133, this is for God's statement of the daughter, she says that there was some matrimonial discord going on between the parents, but the mother had taken some pill for which she has right, but there is no FSL report as per the counter affidavit of the case diary. I know that point on the previous occasion. So 13 years.
Nothing has been recovered. So pill is not the reason for death.
Nothing is.
Pill is not the reason.
So there is no reason for the death. So I cannot be, since it's a case under 103, not under section presumption cannot be done because of if I read section 304B, dowry death is not a case of dowry death or since there has to be a direct allegation. What is the reason for death is not assigned, and in the postmortem report it's categorically observed that the injuries are not sufficient to cause death in the ordinary course. Which minus is categorically observed nowadays. Above, second point, above noted bruise injuries or contusion is antemortem in nature caused by, but this is not sufficient to cause death in ordinary course of nature.
Where is the state?
State had filed as counter affidavit. She has also stated in the para 6 of the counter affidavit the same fact. Languishing, we have a 13 years old daughter to maintain minors. I'm in languishing custody since 18/10/2025. I have no criminal antecedent.
There was previous injury found?
Injuries found. Whatever I have observed, there were injuries found, but that is categorically observed that these were not
various antemortem injuries.
Various antemortem injuries, not
yes, antemortem injuries.
Antemortem injuries, but not sufficient to cause death. That's my point, It was not the doctor has categorically observed. Maybe there was some scuffle between them, but that was not sufficient to cause a death. The case is under section 103 of BNS, not under section 304B or other sections, minors. If that had been the case that no, for these injuries she has suffered death and the cause of death is not being ascertained by the doctor.
Madam, what is the postmortem report?
Postmortem report, that has been given.
I am not able to read it.
Minus were highly basis. It will be helpful for minus.
The market.
This is the gist of it has been noted in the paper. Point number 2. And this same has been stated at para 6 of the counter affidavit. Last point may be kindly transfer. Point number 2.
Point number 2.
Take a bottom है. Point number 2 में देखिएगा above noted antemortem injuries are not sufficient to cause death.
Yes, what do you have to say, madam?
But not that has been kept for the FSL report.
FSL report में कुछ नहीं आया.
Yes, आया नहीं लेकिन ये दिया momentary calculated.
That's right.
Yes.
That's right. Nothing has come.
Okay,
The cause of death is uncertain.
Absolutely
uncertain, but it also that one is very important. Witness is and we have looked to para 108.
That's right. The doctor.
And 113. Yes, but they have.
What has she said? What has she said?
They have stated doctors, apart from doctors, independent witnesses have stated कि प्रताड़ित किया जाता था.
Suicide का केस तो है नहीं. She died. She died, but doctor says that it was not sufficient. The injury was not sufficient.
Absolutely.
And in the FSL also nothing has come. 13 years marriage है. कोई allegation तो नहीं है डाउरी का.
Allegations तो है
डाउरी का.
Witnesses.
डाउरी का.
Witnesses have stated.
FIR में डाउरी का allegation.
FIR में बोले कि जनरल ऑब्लिगस एलिगेशन थी चार्ज अकाउंट आफ्टर 30 डेज. ये चीज जब डॉक्टर बोली है कि इन लोग के बीच में झगड़ा चल रहा था पैरा 133 नेक्स्ट पेज पे है. And this husband took the wife to the hospital. Para 133 is the next payment. That's categorically stated that he has taken all the relatives of the information.
Custody कब से?
18-10%.
Witnesses भी बोले कि 15 दिन पूर्व इनकी बहन को दामाद के द्वारा मारपीट किया गया था.
तो आप लोग कोई एक्शन ही नहीं.
1810
2025.
Actions कोई इंटरफेयर नहीं करना चाहते.
आप हॉस्पिटल में तो नहीं लेके गए.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the husband of the victim and the marriage was performed 13 years prior to the date of occurrence. He has also submitted that one girl child was born out of wedlock. He has further submitted that though the victim was found dead in matrimonial home with antemortem injuries, but as per the opinion of the doctor as recorded in postmortem report, the injuries found were not sufficient to kill a person. He has also submitted that FSL report was called for, and as per FSL report also, nothing was found. He submits that the daughter of the victim has stated that there was fight between the petitioner and the victim, and the victim had taken a pill, but in the FSL report there is no symptom of any death on account of any poisoning or pill. The petitioner is in custody since 18/10/2025. The Learned Counsel for the state has opposed the prayer and has submitted that there was there was fight between the petitioner and the victim, and ultimately the victim was found dead. After hearing the Learned Counsel for the parties and considering the aforesaid submissions by referring to the postmortem report and the FSL report, चार्ज फ्रेम हो कोई गया the charge sheet has already been submitted. The petition is likely to be enlarged.
Serial number 33, DT.30.04.2026. of 2026.
Yes, petition. Sorry? Is it your case, Daddy? They did
On the last occasion also, we used to direct the executive to file the counter. The case is
the murder weapon was recovered under your confession statement.
the X was recovered, but that was not the subject matter of the crime. The Lordship can see, first of all, Lord, I would like to place the evidence. It is very relevant. Yes,
Place the?
Place 12.
Yes, please.
निवेदन पूर्वक कहना है कि मैं चंदन टू इन्फॉर्म जिला गढ़वा के निवासियों श्रीमान को सूचित करते हुए कहना कि मुझे ग्रामीणों के द्वारा जानकारी इट इज वेरी इंपॉर्टेंट नॉट बाय द हस्बैंड दिनांक 13/10/25 की रात्रि 8:30 बजे मेरी बहन सुष्मिता देवी डिसीज उम्र से खाना बनाने के बाद घर के अंदर सोने चली गई एवं उसका पति छोटेलाल मीन हस्बैंड मेरी बहन के द्वारा मना करने के बावजूद घर के बाहर सोने की बात कर घर के बाहर सोया, किंतु लगभग 10:30 बजे मेरी बहन का पति छोटेलाल मीन ग्रामीणों को हल्ला करके बताया कि मेरी पत्नी का किसी ने हत्या कर। So my lord, this is my lord the very important. The deceased was sleeping inside the house. The husband Chotelal Min was outside the house, and one child is also there in the house. But the FIR shows one mobile phone and one cap was found near the place of occurrence. And in the mobile phone, there is one photo of the petitioner who was identified as a petitioner. On that basis, the petitioner has been arrested, and subsequently, one X has been recovered on the basis of the confession it is alleged from the river. But so far as the postmortem report is concerned, the doctor says the deceased has sustained the injuries caused by ardent burns. So that recovery is also not connected with the crime. Now the husband, the later part of the FIR, the second part, which says ज्ञात हो कि इससे पहले भी छोटेलाल मीन के द्वारा पूर्व में मेरी बहन के साथ मारपीट कर एवं आग लगाकर जलाने का प्रयास किया। So entire allegation is would have been asserted by the.
How are you related?
That is the only that mobile one photograph is in the mobile. The last occasion I have also submitted before Lordship. That mobile was not connected with me during the course of investigation.
Yes, tell me.
Neither the service provider
what is there to
is
connect
there
the petitioner apart from that photo or whatever it is?
These petitioners in connivance with the husband of the deceased Milke, they have planned and murder the deceased.
So he is a hired criminal.
Yes, Lord. That has been came in the case study and witnesses have also stated. And apart from that, Lord, this confessional statement is also there, Lord, wherein उन्होंने confessional statement में भी ये बोला है कि हम रमेश बिंद द्वारा लाया गया टांगी से सुस्मिता देवी के सर पर मार दिए जिससे उसके सीट से खून बहने लगा तथा उसकी मृत्यु हो गई।
Ramesh Bindi is not third person, not husband.
नहीं तो
Husband नहीं.
they are all in conspiracy, not husband के कहने से उनका आया मतलब associates जिसको कहते हैं, they all are associates.
तो husband बाहर सो रहे हैं।
That has came in the FIR, उसको तो हम लोग कुछ नहीं कर सकते. Whatever.
And he hired these persons to kill his wife.
Yes, and moreover,
इनके against में क्या है?
इनके
Apart from ये story जो आप सुना रहे हैं।
इनके अगेंस्ट में यह है मिलोट कि उनके कहने से उनके निशाने पे प्रयुक्त लकड़ी काटने की टांगी की सुगागी डैम से बरामद किया गया जिसको
डैम से बरामद किया।
जी मिलोट उन्होंने बोला कि जो जिससे मैंने एल्ज ऑफेंस किया था हम उसको निशानदेह पे हम उसको ये उपयोग प्राप्त करवा देंगे। तो दैट हैज बीन गिवन इन द पैराग्राफ 134 ऑफ द केस डायरी। And postmortem report is also stated that causes of death is due to the heart and blood substances.
Not tongue. आपने उसको एफएसएल में भेजा?
नो मिलोट इसको
तो कैसे कनेक्ट करेंगे?
इसको आप उसको रख दिया गया था मिलोट उसको मंगवा देंगे।
कहाँ से मंगाना? भेजा ही नहीं है तो एफएसएल में?
इसके पहले वाला
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case only on account of suspicion. He submits that the husband of the victim was said to be sleeping outside the house and the victim was inside the house and she was found dead inside the house. He submits that only on the basis of one phone having the photograph of the petitioner, the petitioner has been made accused. The learned counsel for the state has opposed the player and has submitted that the petitioner and others were hired by the husband of the victim to kill the victim.
That is not correct. It was hired by the Rakesh Bin, not by the husband. का कहीं connection ही नहीं सो.
Hired by one Rakesh Bin to kill the victim. She has also submitted that the murder weapon was recovered from which was a tangi.
Yes.
Which was a tangi. Upon the confession statement of the petitioner. To this, the counsel for the petitioner submits that no blood mark was found, the weapon was not sent for FSL examination by FSL, and the postmortem report reveals that the death was by hard and blunt substance. The petitioner is in custody since 23/12/2025 and charge framed. The charge sheet has been submitted. After hearing the learned counsel for the parties and considering the fact that the petitioner has been made an accused in this case on account of suspicion, and charge sheet has already been submitted, the petition is directed to the enlargement.
Serial number 34, BA 2805 of 2026.
Cyber crime versus. The allegation is that he found with his mobile phone and suspicious call was there.
Sorry, one mobile.
One. No victim were identified in this case. There is no criminal antecedent and there is no illegal transaction.
What do you say?
Box it in para 9 of the case diary. Para 9.
ये क्या है? पूरा कहानी है? सब इन्हीं का है?
सब इन्हीं का है। Sole accused, Your Lordship, on suspicious this petitioner is arrested with mobile, Lordship, and in mobile screenshot. The entire contents were found, Lordship, whereby how he obtained the extorted by sending the messages for providing the sex services. Categorically described in para 9 Lordship, each and every context. अभी लेन देन की बातचीत की गई तथा पेमेंट लेने की बातचीत हो रही है, धमकी दिया गया है, all things are discussed.
Contents of the mobile.
And the victim himself has lost the FIR.
That is also described in.
Who has lost the FIR?
उसी पारा में जो छोटा पारा में आ गया, व्हाट्सएप विवेक ज्ञानी हजारीबाग नाम से उसके मोबाइल नंबर से पैसा का लेन देन की बातचीत किया था। अरुण मंडल आधार कार्ड संख्या नंबर में 3 लाख रुपए ज्ञानी प्रसाद को दिया गया, राजेश मंडल आधार संख्या, जिसका उसके बाद बोले हैं हटाने तथा वीडियो ब्लॉक करने का जो रिक्वेस्ट किए बातचीत किया गया है। There are messages whereby the victims requested to delete the video. Lordship,
किसी का स्टेटमेंट नहीं है, कोई विक्टिम नहीं है, मोबाइल के कंटेंट्स पर ये अपने से समझ जाएगा। किसी का स्टेटमेंट
इन्हीं का मोबाइल सेट है, इन्हीं का मोबाइल सेट में
बस मोबाइल के आधार पर ही ये केस बना है, किसी का स्टेटमेंट मिल गया।
How he sent the messages, how he received the messages, how where from he brought the amount, Lordship, and that amount is targeted.
He has not also verified from the bank that such amount has been transferred.
But he had to prove, Lordship. Burden upon him. Mobile seized from him.
Only on basis of seizure of mobile, entire allegation cannot be proved till victim does not support the case. No victim appears, no transaction from bank has been verified. Whether transaction is legal or illegal.
ये किस तरह का वीडियो का डिलीट करने के लिए बोल रहे हैं? What kind of?
Actually, one type of cybercrime also, Lordship, in several websites, he uploaded his email ID and other identification, and person called him, then he given the video call service and other sex services and blackmailing. After obtaining his screenshot and made the video and blackmailing.
आप उनको इतना बताइए, कोई भी विक्टिम आइडेंटिफाई
विक्टिम के बारे में है, लेकिन मैसेज में जो डिस्क्राइब किया होगा कि किसको कॉल किए हैं, उसके क्या कन्वर्सेशन है, ऑल दिस थिंग्स डिस्क्राइब्ड इन दिस थिंग्स.
But no victim as such has been identified. Your investigation is complete.
Yes, completed.
Heard the learned counsel appealing on behalf of the parties. The counsel for the petitioner submits that the petition has been.
सारे अकाउंट डिटेल्स जो विक्टिम्स का था उसके लिए कॉरेस्पॉन्डेंस किया गया है.
अभी तो बेल होगा ना, अभी क्या होगा? The learned counsel submits that only one mobile was seized from the petitioner, and on the basis of certain materials in the mobile, the petitioner has been made an accused in this case. He submits that no victim has been identified and no further witnesses have been examined to link the petitioner with the alleged offence. The learned counsel for the state has referred to paragraph 9 of the case diary to submit that all the details based on the recovery from the mobile has been mentioned. However, during the course of argument, the learned counsel has not been able to point out any victim or any person whose statement could be recorded on the basis of such materials / WhatsApp chats.
Investigation is continued or
He submits that investigation is continuing and further material would certainly come from the concerned banks / victims. To this, counsel for the petitioner submits that the petitioner is in custody since 11/2/26. Charge sheet not submitted.
ट्रैफिक नहीं ऐड पर भाई केस डायरी जो मेरे पास प्रोवाइड किया
Charge sheet नहीं हुआ अभी तक.
मेरा इंफॉर्मेशन उसके अनुसार सबमिट किया है.
However, the counsel for the petitioner has further submitted that charge sheet has already been submitted, but this is being disputed by the counsel for the state. After hearing the learned counsel for the parties and considering the materials in the case study so far, no victim is said to have been identified. However, the petitioner has submitted that the charge sheet has already been submitted. If the charge sheet has been submitted, the petitioner is directed to be enlarged on bail. If it has not been submitted, the petitioner will not be released. As of today. Okay? आप समझ लीजिएगा, अगर आज तक आपका चार्ज शीट हो चुका है तभी आपका बेल नहीं हुआ है तो आपको बेल को रिलीज नहीं करेंगे. क्लियर?
कंटिन्यू करें. पास ओवर केसेस. Serial number 3, ABA 7264 of 2025.
We can't have repeated passovers like that. Repeatedly, this matter has been passed over. We can't have it like this. No, we have other cases also to be taken. Counsel for on the first call the matter was passed over, and on the second call the petitioner, counsel for the petitioner again prays for passing. Post on next Wednesday. That's it. You have to choose the urgency. कहाँ ज़्यादा urgent काम? I can't do it. Should I go to it? Yes, still.
Next Wednesday or Thursday?
Thursday, sir. Next Thursday. Anticipatory bail का केस नहीं है, बता दीजिएगा आप किसी को. You know that, no? So, एक हफ्ता और सांस लीजिए आराम से.
Serial number 6, BA 11940 of 2025.
Yes, please. One mobile, one SIM.
Yes.
No anticipatory.
No.
क्या बोलना आप?
There are 282 crime link and 10 FIRs as per paragraph 33 of the case diary also.
282 crime link.
And 10 FIRs.
10 FIRs. दिखाइए सर.
That is described in para 33 of the case diary. There are 2 victims also left out who have been cheated.
Bail तो नहीं हो सकता. 2 victims and 10 FIR against you. अलग-अलग स्टेट में हुआ होगा. Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that one mobile and one SIM was recovered from the possession of the petitioner, and as per his knowledge, he has no criminal antecedent, and he is in custody since 28/9/2025. आप उनको दिखा दीजिए भाई. The learned counsel for the लाइव जरा हमको
देखे हो इनके सीनियर पुराण पढ़े थे
देखिए the learned counsel for the state has opposed the prayer and has submitted that as per the case diary there are 282 crime links and 10 FIRs relating to cyber offence have been registered against the petitioner at different locations. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petition on bail constituted.
Serial number 9, AVA 932 of 2026.
Yes, please. Petitioner.
Serial number 9, AVA 932 of 2026.
Yes. Yes, please argue your case. You want to pass over? On the first half, this case was passed over. When the case is taken up again, there is a prayer for Passover. Post this case on next Thursday. Next.
34 में चार्जशीट हो गया है मोबाइल में आपने
उससे कोई मतलब नहीं है ना हो गया होगा कभी हो जाएगा किसके साथ हम नहीं जानते
स्टेटस शो कर
कोई बात नहीं देखिए क्या है ना कि कभी कभी आदमी को एग्जैक्ट पता नहीं ठीक है क्योंकि चार्जशीट होने पर बहुत सारी चीजें आ सकती है ना
Serial number 16, BA 2751 of 2026 with serial number 17 and 18.
Please allow case of cybercrime from the petition of this petitioner is a recovery of 3 mobile sets with single SIM card bullets. The seizure is at page 27 and bullets. I have studied paragraph 22. He has one anti-SIM, but he has already been acquitted in that case. I have the acquittal order on this. And I have also stated in paragraph 22 of my petition bullets.
Where is the acquittal order?
Yes. Is the acquittal order on this?
Which case is not? किस केस का है
किस केस का है केस ही है दैट हैज कम
आप बताइए आपके अनुसार एंटीसीडेंट का केस नंबर क्या है
उनका है वो साइबर अपराध कानून कांड संख्या 11/2018
साइबर केस नंबर
11
इसी में
acquittal
और क्या है और विक्टिम नो विक्टिम
three mobile sets with one SIM card, one anti-set in which he has already been acquitted, no victim had turned up bullets.
or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that, as per the allegation, petitioner was found with 3 mobile and 1 SIM. But no victim has been identified so far during investigation. He has further submitted that he has one antecedent in connection with cyber PS case number 11 of 2018, but he has been acquitted in the same case. A copy of the judgment of acquittal has been produced by the petitioner before this court. It has also been shown to the counsel for the state proceeding. After hearing the learned, the counsel for the state has opposed the bail. However, the aforesaid facts narrated by the petitioner is not in dispute. Charge sheet submitted? चार्ज शीट नहीं?
No.
कब से कस्टडी?
हम कस्टडी से 22-26
किसी का बेल हुआ है?
हुआ
The learned counsel for the चार्ज शीट होने के बाद,
1 महीना के बाद लग दिया
चार्ज शीट होने के बाद, नॉट प्रायर टू चार्ज शीट। दूसरे के केस में मत बोला करिए भाई,
हम तो एक ही है।
एक ही है।
हाँ,
नहीं देखिए वो कितना गुस्सा के देखते हैं आप। उनका तो ऐसे ही रिजेक्ट करेंगे। सुनिए ऐसा है, बिना चार्ज शीट के करना चाहिए। 16 को हो जाएगा चार्ज शीट। सिंस तो फिर ऐसे ही 16
तक हो जाएगा।
हाँ?
उससे पहले हो जाता है 90 डेज के बाद तो बेनिफिट मिल जाएगा, सस्पेंड होगा।
90 डेज आ जाता है, 16 को रख दिया जाएगा।
इसीलिए तो हम जानना चाह रहे हैं। आपने काउंटर्स में फाइल किया?
हाँ, काउंटर फाइल किए हुए हैं।
देखिए हम आपको बेल फाइल करने से रोक तो नहीं सकते, लेकिन साइबर क्राइम में जब तक चार्जशीट नहीं होता है तब तक कोई मतलब नहीं है, क्योंकि यू डू नॉट नो विक्टिम इज भी स्ट्रेस हो जाएगा। एट योर रिक्वेस्ट हम इसको रख देते हैं 17 तारीख को।
15 तक
80 और 90 डेज के बीच में चार्जशीट हो जाता है, 15 या 14 को रखने से चार्जशीट हो जाएगा। जो हम लोग देखते हैं बेसिकली।
At your request, I am adjourning.
Yes. उस दिन नहीं होगा तो
हाँ।
ठीक, इसको आप रख लीजिए। सिर्फ यही वाला केस रख रहे हैं, बाकी इनका तो केस ऐसे ही रिजेक्ट हो गया।
मेरा रिजेक्ट नहीं होगा।
एंटीसीडेंट है ना आपका?
वो तो जानती है, आज का समय जो हो रहा है, हम लोग का एंटीसीडेंट बनाया जाता है। कोई अपना मोबाइल पे
आप भी एक कार्ड FIR कर दीजिए कि एंटीसीडेंट बनाया जाए। सर देखिए, आई टेल यू वन थिंग, at the stage of bail, right, we have to adopt the standard. एक स्टैंडर्ड नहीं करेंगे तो कैसे चलेगा? फिर आप बोलिएगा उसको दे दिए, इसको नहीं दिए।
उसके लिए नहीं बोला।
इसीलिए हमारा एक स्टैंडर्ड है भाई, आपके पास ऑप्शन है। बात ये कि एंटीसीडेंट में इसमें हम नहीं देते, ये मेरा अपना डिस्क्रिप्शन है ना, अपना एक क्राइटेरिया है, हम अपना बनाए हैं क्राइटेरिया, नहीं देते। और खराब से खराब केस में भी जिसमें एंटीसीडेंट नहीं है आपको बेल दिए हैं, ऐसा तो नहीं है। तो फिर हम एक स्टैंडर्ड अपना बनाए हैं, अपना एक स्टैंडर्ड क्राइटेरिया बनाए हैं। हम
एक एंटीसीडेंट देना चाहिए, दूसरा नहीं।
उसका भी
स्टडी को देख के एंटीसीडेंट में, और दूसरा तो एकदम मत। एक एंटीसीडेंट
नहीं,
इसलिए कि इनोसेंट में भी फंसता है।
इनोसेंट होने के बाद दोबारा लिखे। अच्छा कोई बात नहीं, ये वाला केस जो है BA नंबर ये सब टैग किया हुआ है। At the request of the learned counsel for the parties, pose this case on, बताइए।
14th को रख दिया जाए।
14th में?
Yes,
it will be open to the counsel for the state
To see, yes.
to produce, to inform this court about any further material which might have been collected till the filing of the charge sheet.
Serial number 19, BA 2756 of 2026, along with serial number 20 to 22.
The case of cybercrime, the recovery of 2 mobile sets with 2 SIM cards. That
Two mobile with 2 SIM
two SIM card. One victim has turned up in the course of investigation as a victim of 1,000. That has come in the counter affidavit.
Yes.
He has no criminal history, which I have stated in paragraph 22.
Yes, what are you saying? State?
There are 97 crime link in the photo also, and one victim traced out to and he stated that he had cheated.
ये जो crime link का कहानी है ना, it is basically attempting. 97 फोन किए उसमें से एक आदमी
वो acknowledgement was somebody made complaint in the portal that I have been cheated and thereafter
नहीं, not necessarily cheated. मेरा ये कहना है कि अगर मान लीजिए actually somebody has been cheated, तो बात होता है दूसरा. एक होता है कि somebody making an attempt में भी crime link आता है. People are making attempt में भी आता है crime link.
attempt भी रहेगा और cheated है उसमें भी.
Victim तो आपका एक ही, आप ultimately एक ही victim को identify
1000 का one victim.
ठीक है, और वो भी जो crime link है उस पर कोई अलग-अलग FIR भी नहीं issue हुआ है. The learned counsel for the petitioner submits that 2 mobile and 2 SIM is alleged to have been recovered from the possession of the petitioner and only one victim could be identified. He submits that petitioner is in custody since?
On custody is 18/1/26.
18/1/2026. Charge sheet has been submitted. Charge sheet has already been submitted. The learned and the petitioner has no criminal antecedent. The learned counsel for the state does not dispute the aforesaid submission, but has submitted that altogether 97 crime links have been found. But the fact remains that only one victim could be identified. After hearing the learned counsel for the parties and considering the fact that charge sheet has already been submitted and the petitioner has no criminal antecedent, the petition is ready to be in some way.
BA 2807 of 2026.
So this is for civil investigation. As per instruction, can I withdraw this?
हमने क्या किया, विड्रॉ कर दिया हमने. आपने क्या किया? आप क्यों इतना चिंता कर रहे हैं? मतलब रिजेक्ट कर दिया, मेरिट पे कर दिया रिजेक्ट, अब विड्रॉ नहीं हो सकता. आप तो बड़े अच्छे प्रैक्टिशनर के साथ काम करते हैं, काम सीखिए. JK कश्यप के साथ है ना, किनके साथ है? एक दिन आपको मैं JK कश्यप के साथ देखा. नहीं, अब ऑर्डर होने के बाद ऐसे रिकॉल नहीं होती. कौन है इसके पिटिशनर? Who is the petitioner in this case?
2807 Rahul Ranjit.
आप ही का मैटर.
There's a recovery of one mobile set.
ये साइबर क्रिमिनल के साथ ताज बन गए.
There's a recovery of one mobile set.
One mobile.
2 SIM card.
2 SIM.
On custody since 18/1/26.
18/1/26.
He has no criminal antecedent.
Any victim?
No victim. No victim is developed.
इसमें भी आप लिखेंगे 97 crime links?
नहीं, crime links.
Heard the learned counsel appealing on behalf of the parties, the counsel for the petition submits that 1 mobile and 2 SIM are alleged to have been recovered from the possession of the petitioner, and he is in custody since 18/1/2026, and charge sheet has already been submitted. He has submitted that petitioner has no criminal antecedent and no victim has been identified. The learned counsel for the state has opposed the pair. However, the aforesaid submissions are not in dispute. Considering the fact that charge sheet has already been submitted and the petitioner has no criminal antecedent, the petition is directed to be enlarged.
Serial 21 BA 3063 of 2026.
One mobile phone with one SIM has been recovered with this one victim.
Just a moment. One mobile
With one SIM.
one SIM, one victim.
Only one victim, para 51 number.
No antecedent.
No antecedent. And same custody 81.
18/1/26. आप बताइए.
One complaint of one cyber link है, complaint है.
बताइए. कंप्लेन है कि केस इंस्टीट्यूट हुआ है?
One case. Complaint.
कंप्लेन है ना, तो वन विक्टिम हो गया ना.
There are 24 complaints in cyber portal. 24 complaint
The
and 1 victim. Wow,
20
72,000.
24 complaint. Complaint means
24
FIR
complaint of
registered.
cyber.
FIR registered.
नहीं.
नहीं ना. The antecedent तो नहीं बोल पाई.
And 1 victim of 72,420.
The learned counsel for the petitioner submits that the petitioner is in custody since 18/1/2026 and 1 mobile and 1 SIM is alleged to have been recovered from the possession of the petitioner and 1 victim has been identified. The petitioner has no criminal antecedent. The learned counsel for the state has opposed a prayer and has submitted that there are 24 complaints in the portal. However, it is not in dispute that no criminal case apart from the present has been instituted so far. As per the case study, correct? To this, counsel for the petitioner has submitted that charge sheet has already been submitted. After hearing the learned counsel for the parties and considering the fact that charge sheet has already been submitted and no other criminal case appears to have been instituted against the petitioner, the petition is directed to be matrimonial.
Serial 22 BA 3064 of 2020.
One mobile, 2 SIMs, one in the name of petitioner, one in the name of another person, one victim,
One mobile,
with 2 SIMs.
2 SIM.
One is stand in the name of the petitioner, another in another person, and one victim, another.
One victim.
No
Antecedent.
antecedent.
One antecedent.
No antecedent.
No antecedent. On the day,
इसमें 15 complaint है लोग की पेपर नहीं है.
15
और 1
complaint.
victim 8,997.
Same order होगा. 15 complaints लिखिएगा. ठीक है, in portal, but no criminal case instituted. Or custody.
Same, 18/1/26.
18/1/26. Charge sheet sums.
Charge sheet.
Okay.
Serial number 23 BA 2757 of 2026 with serial number 24 and 25.
Sorry.
Withdraw.
Sorry.
No rush. On your pen.
The learned counsel here 2757.
Rush.
The counsel for the petition seeks permission to withdraw this bail application. Accordingly, this is dismissed as withdrawn.
Sign for. Diary.
वो शायद दोनों केस में लगेगा. सेम डायरी रखी. अच्छा यूज लगा इसका.
Serial number 24 BA 2758 of 2026.
In this case, there is a recovery of 2 mobile sets with 2 SIM card. That is page 20, the seizure list is at page 29.
2 mobile, 2 SIM.
Yes. And custody since 6/2/26.
Charge sheet submitted.
Yes, charge is submitted. No antecedent.
1 victim is cast out, that is discharged past 60 days.
1 victim हो.
One victim is there.
कितना का अमाउंट है?
Report से ये amount report नहीं है.
1 victim is there.
Yes, one victim.
That is
Or the learned counsel is pleading on behalf of the
past
parties.
60.
The counsel for the petitioner submits that 2 mobile, 2 SIM has been recovered, is alleged to have been recovered from the possession of the petitioner, having no criminal antecedent. The petitioner is in custody since 6/2/26. Charge sheet has already been submitted, and during investigation, only 1 victim could be identified. The learned counsel for the state has opposed the prayer for bail, but the aforesaid facts submitted by the petitioner is not in dispute. Considering the fact that charge sheet has already been submitted and the petitioner has no criminal antecedent, the petition is directed to be matrimonial.
Serial 25 BA 2795 of 2026.
Rush. There is recovery of 2 mobile and 2 SIM. Rush. No antecedent and no victim. Rush.
2 mobile, 2 SIM, and
2 SIM.
1 victim.
No rush. There is no victim and no criminal antecedent.
Heard the learned counsel's opinion on behalf of the parties. Custody कब से?
6/2/24.
Charge sheet submitted.
Rush.
The learned counsel for the petitioner submits that the petitioner is in custody since 6/2/2026, having no criminal antecedent. 2 mobile and 2 SIMs were allegedly recovered from the possession of the petitioner, and no victim has been identified. The learned counsel for the state has opposed the prayer. However, the aforesaid submissions made by the counsel for the petitioner is not in dispute. Considering the fact that charge sheet has already been submitted and the petition has no criminal antecedent, the petition is directed to the
Serial number 35, BA 2816 of 2026 with serial number 36 to 39.
There's one mobile with one SIM. The SIM belongs in the name of the wife of the petitioner.
1 mobile, 1 SIM.
SIM in the name of the wife of the petitioner, para 40. And no victim, no antecedent. And 6/1/2026 charge sheet has been submitted.
Is this correct? Yes, state. और कहीं कोई FIR इंस्टीट्यूट नहीं हुआ
नहीं है
और the learned counsel security on behalf of the parties. The learned counsel for the petitioner submits that one mobile and one SIM is alleged to have been recovered from the possession of the petitioner, and he is in custody since 6/1/2026. No victim has been identified, and there is no criminal antecedent. The charge sheet has already been submitted. The learned counsel for the state who has opposed the prayer. However, the aforesaid submissions are not in dispute. Considering the fact that the charge sheet has been submitted, and the petitioner does not have any criminal antecedent, considering the fact that accused has also criminal antecedent.
दूसरा एक आदमी का है, अभी 9 का है जो है उसको विड्रॉ करना।
Petitioner is directed to be enlarged on case. Withdraw वाला कौन सा है? 39 withdraw कराना।
बाकी लोग का कोई डिसीजन नहीं है।
बाकी लोग किसी का कोई
विक्टिम है, किसी का 5000, किसी का 6000 का।
नेक्स्ट केस एक विक्टिम है बस और कस्टडी सबसे
39 withdraw.
Serial number 36, BA 2820 of 2026.
One mobile with one SIM and SIM belongs to the petitioner. That has come in para 51 of the case diary.
One mobile, one SIM, no victim.
No, this one victim. Para 66.
Okay. Custody
Same number 6/1/2026.
6/1/26 charge sheet submitted. ये dispute में नहीं है ना ये बात?
6 कंप्लेन ऑफ कंप्लेंट FIR नहीं है और सिर्फ और वन विक्टिम है 6430।
counsel for the petitioner submits that one mobile, one SIM is alleged to have been recovered from the possession of the petitioner, and the petitioner is in custody since 6/1/2026. He submits that one victim has been identified. The petitioner has no criminal antecedent, and charge sheet has already been submitted. The counsel for the state does not dispute the approach's submissions. However, he has submitted that in the cyber portal there are 6 complaints. 6 complaints?
6.
But
Five.
5 complaints, but no FIR arising out of those complaints is reflected. Considering the fact that the charge sheet has been submitted and the petitioner has no criminal antecedent, he is directed to the enlargement hearing.
Serial 37 DT.30.04.2026.
Recovery of one mobile SIM with
One mobile,
one SIM card.
one SIM.
Custody same year 6/1/26. He has no criminal antecedent.
No antecedent.
One victim has turned up this, that is amount of 2,953.
Same रहेगा. One mobile, one SIM. Custody since 6/1/26. Charge sheet has been submitted. No antecedent. One victim. ठीक है?
One complaint.
The counsel for the state has opposed a prayer, and as however the approached submissions are not in dispute, he submits that one complaint has been found in the cyber portal. However, no separate FIR has been instituted, and one victim तो आप हो ही गया. You do not dispute. चलिए.
There is one mobile, two SIM, one victim of 7,000, no criminal antecedent.
It's the same.
Same FIR, same.
Just same story है ना. One mobile, two SIM,
One
victim,
one victim of 7,000,
7,000, no antecedent.
no 616 custody.
हाँ बताइए, आप बताइए. State सेम है. कोई अलग से कंप्लेंट है इनके इसमें? कोई कंप्लेंट वाला बात लिखिए. The learned counsel for the state has opposed the prayer. However, he does not dispute the aforesaid submissions made by the
complaint है वही 7,000.
victim तो है.
हाँ victim वही.
30 complaint in total.
But no evidence. Okay, the learned counsel for the state does not dispute the aforesaid submissions. However, he has submitted that there are 30 complaints in the portal, but no FIR has been instituted in connection with those complaints. Separate FIR. Considering the fact that charge sheet has already been submitted and the petitioner does not have any criminal antecedents, the petition is directed to be released on the file. हो गया सब?
Remaining cases.
कितना remaining cases है?
12.
क्या सब टैग है?
हाँ, टैग हैशटैग कुछ टैग.
करेंगे तो अभी कर सकते.
Yes.
कर लेंगे?
Actually कल टैग अप करता है सारे को.
क्या चीज?
कल टैग अप करता है
सारे करते हैं.
तो ऐसा करते हैं 11 ही केस है. सुनिए 11 ही केस है. पोस्ट लंच कर लेते हैं. अगर जो लोग आएंगे उनका कर लेंगे, जो लोग बचेंगे उनका कल. क्योंकि नॉर्मली तो पोस्ट लंच एक टाइड अप मैटर है, मतलब टाइड अप या पार्टनर मैटर है जिसको हम बोले हैं कि फर्स्ट केस करेंगे. तो वी कैन डू इट इन पोस्ट लंच. 10 मिनट लगेगा, 2:15 बजे आ जाएगा. 2:15 नॉर्मली हम 2:30 तक बैठते हैं. 2:15 आइए, तब तक हो जाए.